Yes.
Lordship, may I pray for listing of a IA, Your Lordship,
IA for
126, for
IA
withdrawal of money deposited by the insurance company.
in an MSCT appeal.
Yes,
When do you want?
26.
26. Make it 27.
of that. 28 maybe, Lord.
No, don't put on Wednesday or Thursday. Have it on a Monday. Don't put on a Tuesday or Thursday.
27.
You can have it on 27.
Lordship, I have also similar pair for listing of the case on 26 or any date.
IA
No, Lordship, MSC appeal.
for
MSC appeal.
why do you want listing?
Because it was last listed 4 months back. Lordship.
Appeal of which year?
2021. Lordship.
What is the stage?
No, actually, I'm not in this case, sir. Senior Bhumik, senior advocate, GP Bhumik, sir, like he met with an accident. So his case is related to that. He wants the urgent listing of the case.
When?
26 or any other time.
Not 26. Have it on 27. Wednesday. Yes.
Okay.
May I not? First, I'm paying for listing one KRP matter. Admission register for
One
KRP matter. Lord.
ERP, new matter.
Yes, Lord.
When did you file? No, it
No,
will come up
no,
for
no,
more.
Lord. It's 2019 matter, Lord.
19 matter.
Yes, Lord. So last occasion, Lord, in as much as the matter fixed after for 2 weeks, Lord. So already capable to overload. So by Monday, if possible.
2019 matter.
Yes, Lord.
Okay, next Friday.
Friday.
Next Friday. Not tomorrow, next Friday.
Yes, Lord. Yes, Master.
May please, Lord. Lordship, I beg to mention items number 10 and 11.
Yes,
Lordship, I have taken the consent from the other side, Lordship. It may kindly be adjourned for the day.
Your Lordship, in this case, just beg to inform that in item number 10, the respondent number 1 has expired. And the matter, if any, may be fixed for orders on miscase 1419. This is fixed for substitution upon respondent number 5, 6, and 8 since 2012. No order has been passed.
Is it listed?
141.
1419 is there.
Yes,
Pending since 2012.
12. Matter not been listed since 2012 for the first time. It's been listed.
You are seeking adjournment. Why?
Lordship, Mr. Ghosh is out of station, Lordship. All this miscase may be
Your
disposed
Honor,
of with
Respondent number 1 also
substituting-
expired.
So we have to file in a substitution for respondent number 1.
Will when can you file this up? Within 2 weeks?
Lordship, 2 weeks.
But,
Similarly, Your Lordship, in 11 also respondent number 1 expired. In both the cases.
and in both these cases, Madam, you are for the appellant.
Yes, Lordship.
A prayer has been made. No. Let a counsel appearing for appellant, which is appeal, submit that the respondent number 1 has passed away in the meantime, and therefore there is a requirement to file application for substitution of the learned counsel according to this, and is done 2 weeks time.
Lordship.
The old matter,
Yes,
file
Lordship.
it within 2 weeks.
Lordship, date may be fixed in this matter.
2 weeks time to file such application for substitution. Considering that these appeals are of year are more than a decade old, this on when
11, 12 of October.
can have it on yes, on the
Lordship, I beg your pardon, Lordship. Respondent number 1, already the legal heirs are on record, Lordship.
Anjali,
Then she is the wife. The sons, other sons are there.
you can make appropriate application.
Yes, Lordship. No application is needed to be filed, Lordship, because the respondent number 1 is the wife, and the other legal heirs are already on record, Lordship.
Then
So it may be
such
come
a-
up for orders for disposing of the miscase, Lord.
Yes, it can be.
Then next week, Lordship.
Lordship, let the fact that the respondent number 1 has expired be brought on record.
no,
they may-
okay,
No, the other legal heirs are already on record, Lordship. That is not necessary.
we will record.
Yes, Lord.
A prayer has been made for adjournment of the two appeals on the ground that the SP host conducting council is out of station.
Yes, Lordship.
Where your AKRI,
Yes, Your
Senate council for the respondent, however, submit that the respondent number 1 has passed away in the meantime. And therefore, the question of substitution would arise. However, I'm going to when it comes for the appellant submit that the legal errors
Yes.
of the respondent number 1 are already on record, and therefore substitution may not be necessary. So that we let it make this case on when
Lordship, next week, any date, Lordship. Yes, it will come for orders, Lordship.
no, not for others. We'll have to,
Okay, Lord.
Sir, in this case, 1419 is pending.
doesn't matter. 1419 is for what?
Substituting the
Substitution.
legal errors of
Maybe
No,
respondent.
no, it's a matter of 2011, 10, 11. On the 20,
Today's
Before-
21, Lord.
we'll have it on 28 next Thursday.
Thursday. Yes, Lord.
28.
Yes, sir.
Deeply applied.
Development.
My lord, with the consent of the other side, I'm mentioning item number 13.
1-3.
One thing, my lord, my colleague, my lord, Srinath has some difficulty today. He is handling this matter.
1-3 RSA.
Yes, my lord, I have just spoken to Mr. A. Upadhyay over phone and I have taken consent from him.
It is RSA against the state. Appeal against the state.
Yes, ma'am. Appeal against
A prayer has been made on behalf of Sri D. Nathan, senior governor advocate, appearing for the respondent. List after a week.
my lord.
Yeah, please, Your Lord.
Yes.
First, I beg to mention for listing. RFA, my lord, 1121, my lord. This is ready for hearing, my lord. Can it be
Matter of which year? 21.
21? Next week, my lord, as per convenience of this.
Next Friday.
Can it be Thursday, my lord?
Next Friday. No, it come up for order. Then it can do for
It
hearing.
has come, it has already come up for, my lord, matter has been posted for hearing, my lord.
Then by mention number, it not come up for hearing. You have to pass an order for it.
Let it be come up as my orders, my lord, on to next
Orders on Friday next.
Friday.
Give Friday's date.
May I pay for listing of this MSC appeal of 2018, my lord. I am the claimant respondent. Maybe your next week,
Your
my lord.
claimant.
Claimant respondent, my lord.
Next week, next Wednesday.
My lord. My lord.
May it please, Lordship. With the consent of the other side, my lord, I beg to mention item number 18, my lord.
18 years.
My lord, I am the respondent advocate in this matter, my lord. I have little difficulty today, my lord. It can be posted any day on the next week, my
MSC
lord.
appeal.
Yes, my lord. On
You are for
Thursday,
the claimant.
I am for the claimant, my lord. I have some personal difficulty.
Okay, okay.
Thursday, maybe, my lord.
On repair of the ABD, Senate Council for the respondent number 1. Matter is adjourned. Will listed for hearing again on
Thursday,
Thursday. Okay.
deeply obliged, my lord.
28. 28/9.
Also, I beg to mention a FAO for listing for tomorrow, your lordship. It is an admissions FAO,
A fresh matter.
a fresh matter. It is last listed on August, your lordship, 7th of August. We have already taken the steps, and the other side also.
Why tomorrow?
It is a little bit urgent matter, your lordship.
No, what
For
is the urgency?
We have appealed against the injunction order given by the trial court, and already
The mention number will not come up tomorrow unless it's a very urgent matter or a fresh matter. If file needs to be traced out on what's the urgency? First, you have to get up the urgency.
urgency was no stay was granted by the honorable court, and then we take it as notices and already Vakartama and thing and
We'll have it on
Monday
on Friday next.
Monday, your lordship.
No, not a matter for out of turn hearing. Next Friday.
Like,
May it please your lord. Sir, this present revision is filed against the judgment dated, my lord, 23, 24 to 2011, page 32, my lord. The facts.
Other side is appeared.
Yes, my lord.
Names June.
Yes, my lord.
Year of 2011. What is the matter?
The facts are like this, my lord.
Just a minute. Mishra.
My lord.
You are the plaintiff,
My lord, I am the plaintiff, my lord.
sole petitioner.
My lord,
Petitioner is the plaintiff.
My
Suit for
put for my recovery of possession under section 6 of the specific relief act, my lord.
section 6 petition.
My lord.
Under section 6 of the specific relief act.
My lord, here, my lord, my lord, on 31/12/1983, my lord, the plaintiff came into possession of land measuring, my lord,
31/12,
1983, my lord,
plaintiff came into possession.
of a land measuring 1 biga, 1 kattha 10 lusas, my lord,
1 biga,
1 kattha 10 lusas,
10 acres. Okay, then what happened?
my lord, and thereafter, my lord, and on 25/3/1998, he again took another portion of land, my lord.
Yes.
It is measuring 1500 square feet. Total land is, my lord, 1 biga, 2 kattha 10 lusa.
1 biga, 2 kattha.
2 kattha 10 lusas. Now, the allegation in the plaint is that, my lord, on 2/12/1994, my lord, the defendant number 1,
2/12/1994.
the defendant number 1, for defendant number 2, 3, and 4, my lord, disposes the petition.
No, the second plot was acquired by you when?
The second plot was acquired on, my lord, 25/3/1998.
98.
98.
But it was before this, you had taken possession, they had forcefully dispossessed. Or is it 98 or 88?
Sorry, my lord, 88, sorry.
Huh?
Sorry, my lord, 88.
Cannot be 98.
88, my lord, sorry.
Is it 88?
Just notes I have written here. It is, my lord, my mistake, my lord. 25/3/1989.
89.
89.
That is it.
89.
89. Okay. 2/12/1994, what had happened?
On 2/12/1994, my lord, I was dispossessed, my lord.
Plaintiff dispossessed.
Dispossessed. By a defendant number 1, for defendant number 2, 3, and 4.
By the defendant.
My lord.
Okay, then
Then I have deferred the title suit, my lord. It was 11 of 1993. It was subsequently renumbered as 140 of 2007, my lord.
140 of 2007.
Seven, my lord.
Renumbered.
My lord, renumbered.
Then
And my lord, case suit proceeded in, my lord, by judgment dated, my lord, 24/3/2011, my lord.
24/3/2011. Yes, against you.
Yes, my lord. It was dismissed, my lord. Issue,
There is no appeal, therefore you have come up for revision.
my lord. Now, my lord, issue number 7, my lord.
Where? Page
Page 3, the issues are there, my lord.
3.
Sorry, my 34. Page 34 are the issues, my lord. The issue number 7 is the 11, my lord.
7.
7, my lord. Whether the defendant number 1 to 4 disposes the plaintiff on 2/12/1994. Lordship, findings are at page 35, my lord.
35 finding.
35 is the finding, my lord.
Yes.
My lord, while deciding issue number 7, my lord, the learned court below, my lord, basically relied upon the title of the parties, my lord, and also relied upon the evidence of the defendant, my lord. But lordship, here the suit is for the recovery of possession, my lord. Title will not be relevant here, my lord. Now, second thing is that, my lord, defendant.
No, only by mere discussion on the title. The judgment will not go.
I'm coming, my
See?
lord.
Title may not be required. You are only concerned with the disposition.
My lord, disposition.
Even against the rightful owner, still your suit may lie.
My
If
lord.
you are found to be in possession.
Possession, my lord.
Because you cannot be dispossessed without following the due process.
My
That is the mandate of the.
My lord.
So even if they discuss title, unless you show that the conditions precedent, namely that you are in possession of the land
My lord.
in the plot of land,
My
and that was a kind of a settled
My
position,
lord.
not a cursory or one-day position, then the suit will die.
My lord.
What is the finding?
My finding is that, my lord, may I read the issue entire, my
Please, no, read the
lord?
relevant portion.
Lordship, last paragraph, page 7, my lord, page 35, my lord.
Yes.
A perusal of exhibit 3, 4, and 6 was upon which the plaintiff is claiming the suit land as exhibit C is the alleged agreement is not executed by any authorized person of defendant number 1, to which this document nowhere shows that the plaintiff was in possession of the suit land since 13/12/83. PW1 could not specifically state in which portion of the suit land he was in possession, and PW4 in his cross examination reports that he was not present at the time of taking delivery of the land by PW1, whereas PW3 states in presence of PW4, also in presence of PW4, and also in PW4 even does not know the suit land as he deposed in cross. In PW5, the track owner, though deposited in the year 1989, supplied 150/200 tracks of earth, but exhibit 7 to 10 are dated 28/5/1989, 13/10/1989, 27/11/89. So and so. As these receipts are spread over 5 months, the evidence of DW, now this is relevant matter, the evidence of DW white exhibit K, which is the sale deed, shows the defendant purchased the suit land on 7/12/84. And that is the perverse finding, my lord, because the sale deed was of 1994, my lord. The defendant who is claiming to be the owner of the land, my lord, the sale deed he has executed in 1994, my lord. And the finding is that the sale deed was of 7/12/84. And DW2 and 3 being neighbors also affirm the possession of the suit land by defendant number 3. DW6 evidence shows the fact that till the purchase of the suit land, defendant number 3 was by the defendant number 3, the said was
No,
vacant.
the learned court has held that you are not dispossessed.
My lord. Now, my lord, the things are like this, my lord. In a WS, they have nowhere stated, my lord, so since when defendant number 3 was in possession of the land, and the sale deed was of 1994, my lord. And my guess is that, my lord,
Is it a Miyati Pata then?
yes, my lord,
They had a registered sale deed.
this is till 1994, my lord. And they are claiming that in the evidence they have said, my lord, they were in the possession of the land since 1986. But this fact is nowhere stated in the WS, my lord.
No, say, Mishra,
My lord,
in a suit of this nature,
my lord,
documentary evidence may not make much of a difference. It
my lord,
only mainly on oral evidence
my lord,
whether your claim to be in possession has been proved in accordance with law.
Right.
And the fact of possession may not be proved by a document. It has to be proved by oral evidence.
my lord.
Not only by you, by persons who have seen you in possession. But the discussion shows that nobody has clearly deposed, none of the witnesses or your witnesses.
But PW1 has deposed clearly, PW2 has deposed clearly, my lord, that,
No, in his cross-examination, he said something else.
but my lord, defendant who are also claiming to be in the possession of the land, my lord, they have also shown, my lord, that they were in possession. They are claiming that they were in possession of the land in 1986, my lord. But there is no plain to effect, my lord.
No, defendant need not say that they are in possession. If they are in possession, disposition will come, may be proved.
That's what I want to show, my lord. They want to show that since 19,
The burden is cast upon you. The initial owners the owners will shift only when you make out a case, I emphasize that you have been disposed. That for that you need to establish that you were in possession prior to that date when you had forcefully disposed. And that fact has not been.
Lord, evidence of my lord, PW1 and 2, my lord, that had not been second, my lord.
And as you know, the appeal is not provided by the statute.
My lord.
So on the revision, can we go into those aspects? What is the present stage?
Lord, I have no contact with my clients, my lord. Yesterday also tried to contact over the phone, my lord. The phone,
Is there any stay order?
yes, my status quo was there, my lord.
Status quo.
Yes, my lord.
Perhaps will not have to helping you.
Yesterday I tried many times. This phone was, my lord, not reachable.
So you have done your best. Third, the RS Mishra,
My lord.
Senate Counsel for the petitioner. So none has appeared for respondents in spite of names being shown in court. I have to say, the present application has been filed under section 115 of the Code of Civil Procedure against the decree, I think,
My lord,
not an order,
decree, my lord.
against the judgmental decree. I have to term this order dated 24/3/2011, passed by the learned Munsif number 1, Dibrugarh, entitled to number 140 of 2007. The same suit was instituted by the petitioner as plaintiff under section 6 of the Specific Relief Act. Well, Sarah, at the outset, the learned counsel has submitted that under section 6 within bracket 3 of Act herein effect, no appeal lies against any order or decree, and therefore the present provision is satisfied. Para. It is the case of the petitioner that on 31/12/1983 and 25/3/1989, the petitioner came into possession of a plot of land which measures in total as 1 bigha, 2 katha, 10 less. The petitioner alleges that on 2/12/1994, he was dispossessed by the defendant, leading to filing of instant title suit. Full stop. The same was renumbered as PS 140 of 2007. Full stop. Para. Mr. The learned counsel, by referring issues in the impugned judgment dated 24/3/2011, has submitted that issue number 7 is specifically on the point of disposition and was structured in the following manner. That in what whether the despondent number has a is that 1 to 4 dispose the plaintiff on 2/12/1994. Full stop. It is the contention of the learned counsel for petition that the aforesaid issue has been decided by the learned court of the Munsif number 1, Dibrugarh, by taking into consideration irrelevant factors and misreading the evidence, and also by overlooking the relevant factors and the evidence on record. Full stop. He submits that the learned court, in spite of being confined the aspect of disposition, had gone to the aspect of title, which is not the purpose and objective of a suit filed under section of the Act. He submits that the requirement of the of the of the aforesaid provision of law is a fact of possession without the consent of plaintiff from immovable property and without following the due course of law, which according to the learned counsel have been have been duly fulfilled in the present case. Full stop. Sarah. The submission advanced by the learned counsel have duly considered. Sarah. Section 6 of the Specific Relief Act 96 reads as follows. The requirement of the statute can be laid down in the following manner. Number one, there is a fact of disposition of a person from an immovable property. Number two, such disposition is without his consent. Number three, such disposition has been done without following the due course of law. Under such conditions, a suit under section 6 can be instituted for recovery of possession. Sarah. What transpires is that it is the fact of possession which needs to be established before such allegation of disposition. In the discussion made by the learned on Sarah, this court has also noticed that a court adjudicating a suit filed under section 6 of the Act is not required to go to the aspect of title, and the examination would only be on the aspect of possession and disposition. The statute also barred any appeal, unlike any other order or decree passed by a civil court. The objective of such provision is based on the fact that the dispute is only with regard to disposition, and therefore a finality has been sought to be brought by adjudication of the issue by trial court itself. Sarah. This court is also conscious of the limited jurisdiction to be exercised while adjudicating a matter under the revisionary jurisdiction conferred by section 115 of the Code of Civil Procedure. The code has made such jurisdiction a circumscribed one, very certain aspects have been, certain restrictions have been laid down, and the factors under which such jurisdiction can take place have also been laid down. Those can be the said factors are as follows. That having and keeping in mind the aforesaid provisions of law, comma, the present list is required to be examined. Full stop. Para. In the discussion on the issue number 7, comma, this court has noticed that the learned Munsif number 1, comma, Dibrugarh, has taken note of the oral evidence of the 4 numbers of PWs, 5 numbers of PWs, including the plaintiff who was examined as PW1. The court has, however, come to a finding that there was no acceptable evidence on the fact of possession of the suit land by the petitioner plaintiff on the date on which such disposition has been alleged. On the other hand, comma, this court, by taking into consideration the evidence adduced on behalf of the defendant through 5 numbers of DWs, no, not 5, 7, I think, 7 numbers of DWs, have come to a conclusion that the allegation of disposition was not established. The learned court has also held that though certain though an agreement was produced by the plaintiff, comma, the क्या line कैसे the learned court has also the same was the same was not executed by any authorized person of the defendant, and the state document also does not show that the petitioner plaintiff was in possession of the suit. Para. A court exercising revisionary jurisdiction is only required to examine whether the judgment which has been impugned has taken into consideration the relevant factors, or whether the judgment or whether irrelevant and extraneous factors have been taken into consideration. The such jurisdiction can also be invoked if there is a jurisdictional error of the learned court adjudicating the issue, or if the findings arrived at are such which suffers from material irregularity or gross illegality. Those conditions, do not appear to be fulfilled in the present case. Para, in view of the above, this court is of the considered view that no case for interference under section 115 is of and according to the instance, no order is followed.
May please, your lordship.
Yes.
Lordship, I need to take up first, my lord. IN number, my lord, 163221, my lord. This is an injunction application, my lord, filed by the petitioner.
Now we are hearing the main petition.
For my respectful submission, my lord, before hearing the mail petition, IN number 279617 is required to be decided first, my lord.
What is that?
My lord, 2976, with all respect and regard, my lord, I don't have copy because while transmitting the file to me, my lord, from the other council, my lord, that has not been transferred. But from the record, my lord, I've seen that some subsequent developments of default has been brought on record. So those are required to be considered by you.
Doesn't matter. Here we have 2012. We'll hear this here.
Next week, my lord, I
No, no.
today.
Top of the matter. No adjournment.
My lord,
2012 matter, Mr. Alam. We are more than a decade have passed.
my lord, next Tuesday itself, my lord, because my lord, I don't have copy of this IA, my lord.
Doesn't matter. We are not on the IA. We're setting the petition.
Well, that IA is relevant for the purpose of hearing the
Let
next
us see if we hold that relevant, then we'll adjourn.
Then your lordship, my lord, injunction application, I am not pressing, my lord.
You proceed with the main case.
This IA is required to be matter considered. Wherein, my lord,
If we have told you, if we think that the IA would be required, we'll grant it.
My lord.
But this is not the purpose
No,
of
my-
getting an adjournment in a top of the
no,
list.
my lord, my
100 to
intention is
12
not
matter.
to kill the
Even if
time.
it was not under the column top of the list, you would not have granted adjournment. 2012 matter. You do not do, we'll get.
Then, my lord, I am coming, my lord. My lord, this is an application, my lord, section 115 of PPC, my lord.
Three of you are there.
My lord,
Three petitioners.
my lord,
You were what?
I am for the petitioners, my lord.
No, you were what?
We are landlord,
Plaintiff.
plaintiff, my lord, before the trial court.
Suit for
For ejectment and recovery of area rent, my lord.
suit for ejectment.
Ejectment. My lord, case of the petitioner made out before the trial court that there was a tenancy agreement, my lord, between the respondent numbers 1 and 2.
Where is this property?
Property, my lord, at my lord GS Road,
No, in Kamrup.
Kamrup Metro, my lord.
Okay.
GS Road, my lord. This is Bhajanga building, my lord.
Okay.
Wherein Mochi retail outlet is there.
Okay.
Just by the side of Mochi, my lord.
Then they were tenants.
Tenants, my lord. So, my lord, this is the case made out by the petitioner. That's in the month of April 2014,
Plaintiff is the landlord.
landlord.
Tenancy is from which year?
My lord, tenancy had started, my lord, at first. 29, 12,
How many
19,
defendants are there?
My lord.
Two defendants.
two defendants. My lord. Both of them had jointly entered into agreement, my lord.
Defendants were tenants.
Tenants, my lord. But my lord, respondent number 2 had neither contested before the trial court. The matter was proceeded ex parte, not contested before the possible court. Even, my lord, before this honorable court also, there is an order on 25/4/13 proceeding ex parte against respondent number 2.
That's one number two.
25/4/13. That is on record.
25,
4/13.
5, 30, R5. Talk of over. Not contested.
Not the struck of order, no, proceeding ex parte.
Expert. Yes.
Then, my lord,
R2.
R2.
That's one number
R1 has filed WS.
Yes.
All along he has been contesting, my lord.
Mr. Sharma for R1. That's one
Yes.
number one. Okay. Yes.
So, my lord, in this case, this was alleged that, my lord, since the month of April 2014,
April
2014,
2014,
no, my lord, April 2004, 2004, my lord,
2004.
4, my lord.
Yes.
No, no, my lord, the respondent stopped the payment of monthly to the petitioner on and from the month of July 2004, my lord. July 2004,
July 2004,
Four.
no rent paid,
no rent paid, my lord. And even tender to the petitioners, my lord,
paid or tendered.
tender.
Then?
Against that, my lord, this is the case set out by the respondent number 1 before the trial court. That the month rent for the month of July 2004 was tendered to him, given to him, but he had not issued any rent receipt. Thereafter, the same rate was again deposited in the court. And
This
deposit
is
of
their case,
This
that
is
it
their
was
case.
tendered.
Yes.
You, since you did not.
I received, not tendered, they paid this money. But I have not issued the rent receipt. Then being compelled, they had again deposited the same amount in the court. This is their case.
Yes.
In respect of payment of state amount, my lord, the respondent as DW1 had produced and exhibited, my lord,
The suit was, the only basis was defaulter.
defaulter, my lord. Two grounds were there, my lord. Defaulter, number 1, number 2,
Bona fide requirement.
bona fide requirement. So, my lord, the husband of the petitioner number 1 was the breadwinner of the family. He had died, my lord. Now, my lord, respondent number 2, appellant number, petitioner number 2 and 3 have grown. They intend to do their own business.
They
For
are the sons of petition number
Yes, my
1.
lord. Yes, my lord. Son and daughter, my lord.
With their son's daughter, son and daughter.
Daughter, my lord. So the respondent number 2 has now been qualified. He is intending to do his own business. So premises is bona fide required. The finding recorded by the trial court.
How many witnesses did you?
My lord,
How many witnesses did you produce?
two witnesses, my lord. I have
Two PWs.
two witnesses.
What documents did you exhibit? Let us read the judgment of the trial court that clear
My lord, my lord.
Or if you want to-
That may kindly be seen, my lord. This starts from, my lord, page number.
70.
Now, trial court judgment is, my lord, starting from page 30. 30,
30.
30, 30, my lord.
Not 70.
No, my 70 is, my lord, appellate court judgment.
The trial court judgment. That is 59.
My lord, this is my copy of PRV 526. When in, my lord, page 32, the judgment of the.
Doesn't matter. You read the judgment.
My lord, judgment.
What is the date of the judgment?
Date of judgment, my lord, 38 June 2010, my lord.
Yes.
Of the trial court, my lord.
Yes.
38 June. My lord, I am reading the judgment, my lord. This is a suit for eviction of the defendants from the suit property and area rent and future rent, my lord. The case in brief is as follows. By the agreement dated 29/11/1999, the defendant number 1 and 2 took the suit premises on rent for a period of 3 years at the rate of 6,800 from late Vinod Kumar Agarwal, who was the predecessor of the present petitioner's file. Vinod Kumar Agarwal, who was the husband of the plaintiff number 1 and father of plaintiff number 2, 1 and 3. The state agreement expired on 30/12/2002, and a face agreement of tenancy was entered into by the defendant and late Vinod Kumar Agarwal on 30/12/2002 for a period of 3 years. Vinod Kumar Agarwal expired on 29/3/99, my lord, leaving the plaintiffs as legal heirs. Since the month of July 2004, defendants have stopped paying their rent. In spite of verbal requests made to the defendants have not made the payment, and as such, plaintiff sent the pleader notice to the defendant numbers on 21/3/2005, asking them to vacate the suit premises on the ground of default of money payment of rent and bona fide requirement of the suit premises by the plaintiff. The plaintiff are in bona fide requirement of the suit premises and ceased to. Suit proceeded the ex parte against defendant number 2. Defendant number 1 contested the suit by filing her WS, wherein she had denied the allegation of non-payment of rent as well as bona fide requirement of the landlord, was specifically denied. Insofar as the allegation of default is concerned, the defendant number 1's case, as stated in the written statement filed, is that the agreement dated 29/12/99 was not executed between her and late Vinod Agarwal, and that both the defendants entered into agreement of tenancy with late Vinod Kumar Agarwal. This is also pleaded case of the plaintiff, my lord. An agreement of Vinod Kumar Agarwal on 1/4/2003 for a period of 3 years, and the defendants deposited the sum of rupees 2,50,000 to the state late Vinod Agarwal as security deposit, condition that the state security amount shall be returned as and when agreement expires, and on cancellation of the deed, whichever is earlier. It is also stated in the written statement that the defendant paid sum of rupees 1 lakh as advance amount to be deducted every month to the extent of 50% of rent payable, and this amount is yet to be adjusted. And the plaintiff brought the instance suit without adjustment of the advance amount and without returning the security deposit. Defendant number 1 has further stated the plaintiff number 1 received the rent for the month of July 2004, but did not issue rent receipt, for which the defendant had to deposit the rent in the court. It is further stated by the defendant number 1 that after death of Vinod Kumar Agarwal, the rent was enhanced to rupees 7,200 per month, with effect from 1/4/2004. Following issues were framed, my lord, as many as 8 issues were framed by the land trial court. And my lord, during trial, plaintiff examined 2 witnesses, SPW 1 and 2, and defendant also examined 2 witnesses before the trial court.
Let us treat the findings on defaulter.
My lord,
The court
only in
court has said that some
only-
advance was dying.
advance, my lord, that is just refundable on vacation, my lord.
Yes.
Now my TV rear end is more than the advance security deposit, more than.
No, even assuming that it's not noted, they can court take the plea or accept the plea that this advance was there, one is not got
No.
paid, and
No, that's please. With
No,
all
some-
respect, my lord.
some case laws have been relied upon. How do you overcome those case laws, including Supreme Court, that Kanti Swarup mention has been at
No, my lord.
page internal page 6. Is this the correct law? They have they have produced the cash book. to
No,
show
my
that-
lord, they have produced the cash book, my lord, only in respect of payment of one rent for the month of July 2001. Only 1 month, my lord. And only in due consideration of this case book, my lord, the suit was dismissed, holding that he is not a default. There is no, my lord, discussion in respect of subsequent payment, subsequent deposits of the case. Because my lord, mayor filing as a case does not waive the duty and liability of the tenant, my lord.
But there is also the evidence of DW1, who said that it was not only tendered, it was accepted by you.
That is
And
only,
since you have not given receipt, so therefore they had gone to the court as a matter of
that is
abundant caution.
only in respect of.
So the question of the issue of tendering will not come at all. It's much more than tendering. It was in fact paid and you received by it.
That is, my lord, in respect of 1 month, only, July 2002. A suit was filed, my lord, in the year 2006, my lord. During this period also, there was not a single tender.
Where is your averment in the plain regarding defaulter?
Plain, my lord, my document shows a
From-
page,
August-
annexure 1, my lord.
Okay.
It starts from page 15, my lord.
Till date. When did you
Paragraph,
when did you institute the suit?
the suit was instituted, filed on June 2005. June 2005,
June 2005.
my lord.
In paragraph 4, you have please read paragraph 4, page 2.
Yes,
the
my lord.
suit.
Page 2, my lord. The
Page-
defendant did not, had suddenly stopped to pay the monthly rent of the property from the month of July 2004, in spite of verbal request to the defendants to pay the rent of July 2004, but they failed to pay the same.
Till date.
till today.
till 95, 2005,
Four, my lord. Because, my lord,
2005.
five, my lord. Because, my lord,
Let us see your evidence. PW1.
PW1, Rekha Agarwal, my lord.
Got it. Paragraph 5 of your chief. Your sons and daughters have become major now.
My lord. In injunction, the chief, my lord, whatever has been stated in the plate has been corroborated, my lord. May I read the cross-examination of PW1, my lord?
Yes.
Cross-examination of PW1 recorded on 16/3/2009, my lord. Rekha Agarwal. Oh.
Yes. But
Cross, my lord, I'm reading, my lord. মোৰ স্বামীয়ে চাউলৰ ব্যৱসায় কৰিছিল, starting from inception, my lord. মোৰ স্বামী উক্ত ব্যৱসায় গুৱাহাটীত কৰিছিল। মোৰ স্বামীৰ মৃত্যু মৃত্যুৰ ছয়জন ভাই ককাই, মোৰ স্বামীৰ মুঠ ছয়জন ভাই ককাই আছিল। মোৰ স্বামীৰ দেউতা ঢুকাইছে। খ্ৰীষ্টিয়ান বস্তিত মোৰ স্বামীয়ে মোৰ স্বামীৰে দেউতাৰ জমি আছিল। মোৰ স্বামীৰ দেউতাৰ নাম তিহান চন্দ আগৰৱাল। মোৰ সৰুৰে জমিবিলাক মোৰ স্বামী আৰু তেওঁৰ ভাই ককাইৰ মাজত ভাগ বতৰা হৈছে। মোৰ স্বামীয়ে খ্ৰীষ্টিয়ান বস্তিৰ জমিত অন্য ঠাইত জমি নাছিল। গাঙ্গুলী এপাৰ্টমেণ্ট মোৰ স্বামীৰ ভাগত পৰা জমি বিল্ডিং বনাইছে। বিল্ডিঙে তাত ঘৰ বনাই আমাৰ তাত 4টা ফ্লেট দিছে। বিল্ডিঙৰ তাতো কিমান বিল্ডিঙৰ লাষ্ট কিমান দিছে মই নাজানো। মই 4টা ফ্লেটৰ 2টা
we have
flat-
read- we have read.
pilot
that suggestion was negated at page 3, internet page 3 of the cross exam. Second last paragraph.
Second last most, page 3, my lord,
Page 3 of the cross exam.
cross examination.
Please read this part.
Five zero three and 504, Moy, flight router, number is 10110, plate number
No, page internal page 3
internal page 3, my lord.
of the cross exam.
PW1, my lord.
Yes.
More family ভিতৰত মোৰ ছোৱালী এজনী ল'ৰা
No,
এটা
no,
আছে
not that.
মোৰ ছোৱালী
That is on internal page. Internal page 3 of the cross part.
my lord, I am reading internal page number 3, my lord.
Of the cross part.
Cross
Handwritten.
PW1.
one. Isn't it is SMS?
It is established, my lord. Certified copy, my lord. Record photo certified. This is photo certified copy, my lord.
Doesn't matter. You have given it is brief also. Page 3. It's June 2000. 2004 লৈ ভাড়া দিয়া ৰিচিপ্ট মই তেওঁলোকক দিছো। এইটো সত্য নহয় যে জুলাই 2004 পৰা মই ঘৰ ভাড়াৰ ল'বলৈ ৰিফিউজ কৰিছো আৰু বাবে গুৱাহাটীৰ পৰা আদালতত ভাড়া জমা দি আছে।
That
This
is my
suggestion has been negated, Mr. Sharma. Your suggestion that you had
Deposited it.
tendered.
also.
And my lord, in support of this contention, my lord, that they have paid the money, my lord, they have proved before the trial court add their cash book and exhibit number M. Only on the basis of discussion, exhibit M told the entry of payment of rent for the month of July 2004. It was dismissed by the trial. Only consideration of this particular month rent. There is no discussion regarding subsequent month rent payment. Although suit was filed after almost 1 year of default. No whisper is there, my lord, before the trial of the.
That is a private case book, isn't it?
Yes, my lord.
The
Yes.
banker's book of evidence will
No,
not apply.
No. This is their case book, their books of account, they maintain in their usual course of business. They file it and mark the exhibit M. Wherein, my lord, they have shown one column. My lord. Payment of rent for the month of July to the landlord. Trial court has accepted on its face value.
Yes. What about the bona fide requirement finding? By the trial. Did you adduce any evidence regarding bona fide requirement? Issue number 4.
Issue number 4, my lord.
Please read issue number 4, internet page 6 of the trial coaches.
Issue number 4 premises is bona fide required for the plaintiff, my lord. That has been.
Yes. After paragraph page 6,
Yes,
internet
it's
page 6.
clearly page number 6. It is may I read it, my lord?
Please read.
Issue number 4. It is pleaded that by the plaintiff that the plaintiff has bona fide requirement of social. In her evidence, P1 reports that after death of her husband, she and her 2 children are facing financial hardship, and the receipt from the dependents was not sufficient for meeting up the expenditure of the family, including educational expenditure of her 2 school-going children. And as such, she has decided to do some business for income of her family. And the supreme message is the fit place for her business. Defendant number 1 has contended that plaintiff had 4 numbers of flats in a gully apartment in her name, and also a plot of land by the side of the said apartment, which is let out to someone for running motor garage. The plaintiff number is also running her ice cream parlor, PCO gift house, Vodafone connection center in the room, which is next to the supreme message. P1 has, in her cross examination, admitted she has 4 numbers of flats his state appointment, out of state four place, he has let out 2 out of them. And collecting rent therefore, as she has also admitted, she also let out state motor garage. In her cross she is elicited from the mouth of PW1 that room in which PCO is situated is let out to her own brother, from which he collects money, monthly rent. And in PCO, she has a Vodafone connection center in her name. Mere statement that the landlord is in bona fide requirement of the suit premises is not enough. In order to show that he is in bona fide requirement of the suit premises, she has to show that she has initiated the process for which the premises is required. In the instance to till the date of her course examination, she neither approached any authority for obtaining any license for doing the business, which shows that beyond her desire to start a business. She has not proceeded with anything concrete for starting the business. Under the circumstances, I find that the plaintiff are not in bona fide requirement of the suit premises. My lord, for applying and obtaining the trade license or necessary permission, first of all, premises is required to be vacated, my lord. Then, my lord, when I will submit an application, authority will verify whether permission license can be granted for doing the particular business from the such premises or not. This is evident position of fact. Some other tenanted premises are there, my lord, but these are not sufficient enough to meeting up their expenses as well as educational expenses of minors. My lord.
Yes, any decision or anything else you would like to submit?
By tomorrow, I'll submit them. Tomorrow, my lord, with a list of
Yes.
sanctions, my lord.
My lord, my participation before your lordship. My lord, it is a concurrent finding of fact. A concurrent finding of fact. Therefore, the revisional court has very limited jurisdiction. And my lord, I have the Supreme Court judgment that the revisional court should not interfere with the finding of fact by the courts below. So far, the defendant bona fide requirement and the defaulter is concerned, what the court held that the defendant is not a defaulter and she has been paid the rent regularly in the court, as well as a handsome amount of advance amount has already been deposited with the plaintiff. Therefore, on that view of the matter, the defendant cannot be held as a defaulter. So far, bona fide requirement is concerned.
Now, on defaulter, if security or advance is lying,
Yes.
will it take care of a situation or will the factor of defaulter not lie?
No, well, at the time of filing of this suit, because after 2-3 years, the position may be different.
No, not at the time. We are considering from the date of filing of the suit.
Date of filing of the
Suppose on
suit,
the date of filing of the suit,
there
your
was an
case is
advance.
that there is an advance of sufficient amount which can be adjusted. Can that be a defense while filing a suit for
No,
defaulter?
that is my submission.
No. Is there any law on this?
Because the law has already been discussed by the lower appellate court.
No, is there any settled law that if
Yes. it is settled
if the advance is there, then the fee of defaulter will not lie because he can easily adjust with the
Yes.
advance amount.
law. Your lordship kindly read the appellate court judgment on this point. At page 92, the lower appellate court framed 2 points for determination.
92.
90.
Yes.
The learned Munshi rightly decided the and proper appreciation and evidence on record. whether the Munsif has committed whole error in passing the informed judgment. So Lordship then turned to decision and reason thereof. All the aforesaid points are correlated and the points are taken up together for consideration. Issue number 3, whether defendant is a defaulter in payment of rent to premises. The plaintiff in his pleading as well as the evidence stated that the roof covering an area of 1 square feet, detail of which are scheduled below was laid out to the defendant by her husband for the period of 3 years, only monthly rent of ₹6,008, and doing the terms and conditions. The said agreement that it was a fresh agreement of tenancy entered into between the husband, the father of the plaintiff, and the defendant on 1/4/3, commencing from the date of execution of the agreement, a period of 3 years. There, my lord. Paragraph number 10, your defendant number 1, Honorable asked in her written statement that an agreement was between the Vinod Kumar Agarwala and the defendant number 2 was a tenant in respect of the Mrs. predecessor interest of the plaintiff, and lease agreement dated 29/12/99 for a period of 3 years. The defendant number 1 and 2 thereafter in the fresh agreement for lease for 1/4/2003 for a period of 3 years. The defendant had deposited a sum of ₹250,000 as security deposit on condition that the whole security deposit shall be refundable to the tenant as and when the agreement expires and the cancellation of the deed of whichever is earlier. The plaintiffs are silent relating to the return of the security deposit. Advocate. Here, my lord, lordship can skip paragraph page 95. In this connection, he relied the decision of the High Court so and so has become there. On the other hand, the learned counsel for the respondent has submitted the defendant has already paid an amount of ₹1 lakh as advance as security and as security of 2,50,000 has already been paid. As such, the rent has to be adjusted from the aforesaid advance.
Yes.
Paragraph 13.
Paragraph?
In paragraph 13, page 95. In 1994, 2 SCC, which was relied on by the respondent, the Honorable Supreme Court that an adjustment deposit made by the tenant to the landlord should be made even without a specific request by the tenant. From the foregoing discussion that the defendant was a tenant under the plaintiff and regularly paying the rent, and on July 2004, the plaintiff refused to issue rent receipts, and the defendant deposited the rent in the court according to the provision of the Rent Control Act. The rent was mutually fixed at ₹6,000.
You reading which paragraph?
I am in paragraph 14,
On
page 96.
what is emerged?
What has emerged from the foregoing discussion? The fact remains that the plaintiff was
Defendant.
defendant was a tenant under the plaintiff and was regularly paying the rent to the defendant. And on July 2004, while the plaintiff refused to issue rent receipt, the defendant deposited the rent in the court according to the provision of the Rent Control Act. The rent was mutually fixed at ₹6,800 but after the death of Vinod Kumar Agarwala, the rent was enhanced to rupees 7,200 with effect from 1/4/2004. The defendant paid rupees 3,600 in cash, adjusted from the advanced amount to the then landlord. From the above discussion, it appears that the defendant number 1 was not a defaulter, and the learned Muslim number 3 has rightly held that the defendant number 1 is not a defaulter. In this regard, the issue whether the suit premises is bona fide required by the plaintiff, it is stated that the point as well as that the evidence of PW1 from the income of the monthly rent suit premises was sufficient to meet the expenditure of the plaintiff number 1 and has decided to start a business in the suit premises which is fit for any type of business. The plaintiff have no other accommodation to business. The defendant number 1 in his pleading stated that the plaintiff have one shop adjacent to the demise premises where the plaintiff number 1 has a PCO and a rolling ice cream. Plaintiff number 1 earned a handsome amount from the business and is enough to maintain the family expenditure children. The plaintiff also let out a portion of the land to a motor garage in the name of Messrs. Supreme Automobile. The plaintiff have also 4 numbers of flats in the Rangoli apartment situated backside of the road compound and and the rental income of these are also come from the predecessor interest of the plaintiff. Thus from the above statement, it has become crystal clear that there cannot be any financial distress from the braided education of the expenditure. PW1 in her cross-examination has stated that the 4 flats she resided in 2 flats and 2 flats have been let out. She further stated that the PCO adjacent to the suit property was conducted by her his brother on a rent payment to the PCO received rupees 1,000. His brother. She also admitted that the fact that the said PCO there is a Vodafone connection center in her name. In order to show the bona fide requirement of the premises, she has to some positive act that she has initiated some step for which the premises is required. The requirement of law regarding the bona fide requirement is that the requirement by the landlord is genuine. The claim in which motivated the extraneous consideration. Mere desire is not sufficient. Must be honest, genuine need. In this connection, the learned counsel for the respondent has relied on a decision of the Honorable Guwahati High Court in so, wherein there should be a material on record to prove the requirement as honest and genuine. Burden lies on the landlord to satisfy the court. The accommodation was not suitable. It is an instant case to the appellant having 2 flats, Vodafone connection center and PCO, which left out the other brother to the appellant, make the point clear that the requirement of the appellant is not honest and genuine. In such circumstances, I am
What
of
is
the
the
view
meaning
that
of
the
this? Burden lies on the landlord to satisfy the court that accommodation was not suitable.
Yes.
Which
The accommodation means my lord, the amount she has received from the
No. Here, burden lies on the landlord to satisfy the court that accommodation was not suitable.
burden lies on the landlord to satisfy the court. The accommodation is not was not suitable. In the instant case, the appellant has 2 flats. Accommodation is suitable means when the amount received from the tenant is not.
Does make sense?
Remember, both the courts below concurrently held that the plaintiff has failed to make out a case for and the both the courts held, discussed the evidence on record and came to a conclusion that it is not entitled to this. Therefore, another sufficiency, it is a concurrent finding of fact. The jurisdiction under 115.
Yes, that you have submitted.
Yes.
That,
To that
that,
effect, my lord, I
that
have
being a
also
concurrent finding, it should-
judgment.
115 is to be exercised in a very sparing manner.
My lord, I have one judgment.
Yes.
At the Supreme Court. And this was a judgment passed by 5 judges regarding the rent control.
Yes. What is the citation?
I am giving you the copy.
Citation, please.
2014,
2014.
9 SCC, page 78. No, only
And
SCC 70.
paragraph.
My lord, this is the all paragraphs are the main points whether the revisional court can enter into the concurrent finding of the courts below.
Right.
And these 5 cases been held. The 115 cannot be exercised by the High Court to interfere the findings of the courts.
Where?
My lord, from the head note itself,
Not, where is the finding?
my lord, in this appeal, the several rent control act of the different states were cut, and the number of decisions were cited by the court, by the Honorable Supreme Court, and it is held page 43, it was held. We hold that as we must, none of the above rent control act entitled the High Court to interfere the findings of fact recorded by the First Appellate Court, First Appellate Authority, because on reappreciation of evidence, its view is different from the court authority below. The jurisdiction under this act is confined to find out the findings of fact recorded by the court authority below in accordance with law does not suffer from any error of law. The revisional power is not and cannot be equated with the power for reconsideration of all the questions of fact as a court of first appeal, where the High Court is required to satisfy the decision according to the law. It may examine whether the order is going to be put suffer from procedural illegality.
What is the other one?
It is a
2018.
whenever it was 2018-12 SCC, page 5, 7, 4 and 5. Paragraph number 5. The learned counsel appearing for the respondent section 5. to start.
Paragraph 5.
No, my lord, there is no dispute with landlord relationship. One of the requirement has also concurrently held with the rent control act.
Yes, Mr. Alam, anything?
Only three Mr. The lordship cannot see internal page number 10 of the appellate judgment.
Anything else, Mr. Sharma?
Yeah.
Internal page number 10 of appellate judgment.
Appellate judgment.
Appellate judgment.
10.
10, my lord. Page number 10, my lord. Para 11.
Yes.
The counsel for the appellant has argued that the defendant has not paid the lawful rent and as such liable to be evicted.
Not para everything.
Para 11 of the appellate judgment, my lord.
Appellate judgment, para Learned Counsel for, yes, argued it, right.
That counsel for the appellant has argued that the defendant has not paid the lawful rent and as such is liable to be evicted in respect of his claim. He relied upon the following decisions, my lord.
Yes.
These 5 decisions have been placed before the trial court, my lord, which still I am relying, my lord. He further argued that although defendant has not deposited has deposited some amount of rent in the court that has not been deposited as per section 5(4) of the Act of 1972, as such he is defaulter. In this connection, he relied upon the decision of our own High Court, reported in 2005 GLT, supplementary GLT 540, wherein the court held that compliance of a statutory provision under section 5(4) of Assam Urban Areas Rent Control Act is mandatory, failing which the tenant becomes defaulter, my lord. In discharge of this, my lord, this is the onus on the part of the defendant to prove the same that he has lawfully deposited the rent in the court. To prove this fact, my lord, NJ case records are required. Not a single NJ case record was called for at the time of trial, at the time of their evidence, my lord.
It
Only
was called-
chalas, my lord.
It was called for, no,
Please.
it was called for an activity. No, make a correct submission. before the
No, I'm submitting from the part of the record. I'm not submitting anything beyond the record. This is not my habit.
No,
Sir,
no, no,
full
no.
statement, my lord.
Mr. Alam, right. Not that.
With regard, my lord, I'm submitting.
No, we clarified.
My lord, I'm
These are
clarifying, my
matters
lord.
of record.
My lord, I'm submitting for the record. What he has done, my lord. He has exhibited only chalas, my lord. Your lordship cannot see. The appellate judgment, the London appellate court below is considered the same as lawful deposit. Only on perusal of chalas, my lord.
Some next paragraph, paragraph 12 of that page 11
My lord.
is there. He further submitted.
My lord. Ah.
Please read.
My lord, he further submitted that he paid the rent for the month of July 2004 to the plaintiff number 1 who took the said rent but did not issue the rent receipt for which defendant has to deposit the rent under the provisions of Rent Control Act. I have gone through the rent deposit chalas and found that the rent deposit chalas were duly executed. My lord, from this particular sentence, my lord, I am submitting
only land deposit chalans were exhibited, not the NJ case record, my lord. Furthermore, my lord,
Where is it,
In-
where is it required that ethic is, record? needs
my
to
lord,
be,
my lord, requirement,
or proving the challan is not enough?
now, my lord, the requirement is, my lord, for compliance of section 5(4). What is the requirement? My lord, allow
Let us see 5(4) of the urban statement.
mandatory requirement, my lord, while
What is the requirement? Let us-
section 5(4).
Yes.
At the time of my lord, deposit of NJ case, my lord, this is also duty of the tenant, my lord, to give process fee, give notice for servicing the same to the landlord, my lord. And this can be proved only from the NJ case record, whether process fee was paid or not, whether notices were given or not, your lord, for service regarding deposit to the landlord, my lord.
Your submission of yours, is it backed by any history that mayor proving the challan will not do away with the requirement of
There are,
section 5?
there are certain of judgments, my lord, in this regard, my lord.
Not a case that they have not proved anything. They have proved the challan.
Only challan, my lord. That will not work.
You are contending that mayor proving of challan would
Is
not be enough.
is not the charge of the mandatory requirement of section 5(4).
That to contend that, to substantiate that, you need to have some, because type 4 does not talk about challan neither of NJ case. Type 4 lays down
Procedure, my lord.
now the
Wanted
procedure.
to be accompanied with the
Yes,
deposit application.
Since neither of
And then-
those
That
contradicting-
accompanying, my lord, can be revealed only from the NJ case record by repeating the NJ case record only, not from the challan, my lord. And in this case, my lord, 2005 supplementary GLD 540, this has been dealt with, my lord.
Yes.
For the next submission, my lord, your lordship cannot see that WS filed by the defendant number 1 after filing my suit. My lord, in the WS, there is no plea that he had deposited the rand in the, because my lord, this WS filed in the month of September 2005. This is their case that they have started depositing the rand in the month since the month of July 2004. There might have been 14 as a case records, my lord.
September 2005.
My lord.
Where is it?
My lord,
No averment regarding?
WS, my lord.
No averment regarding?
No averment regarding deposit of any rent by way of any NJ challan, NJ case record before the motive. No whisper is there, my lord. In the entire WS. Although WS was filed, my lord, after filing of my suit,
Obvious.
and my lord, after LS default, after 40 months of LS default. Default has been LS, my lord, since the month of July 2004. If they were regular enough, then this might have been pleaded in the WS. No, I am not default. I have been regularly paying the rent in the court. These are the NJ case record, NJ case number. Not a single NJ case number has been mentioned in the WS, my lord. Now, your lordship cannot take a judicial note.
Just in paragraph 12,
Of WS, my lord.
first it asks for which the defendant said to deposit the rent to the provisions of rent contract. You may be correct in contending that it is not
No NJ case number has
and
been
or
mentioned, my lord.
not even reference to the court has
My lord.
Paragraph 18.
18. In the court. Right.
In para 18 also, there is no mention of any single NJ case number.
That's the foundation is there in the pleading. It can be
All right, my lord.
Evidence.
All right, my lord. But in support of this pleadings, my lord, those NJ cases ought to have been called and exhibited, showing compliance of section 5(4), giving of paying of process fee, sending of a notice for service to the landlord. Until and unless those are proved, my lord, this cannot be said to be a valid deposit in the IF law. My next submission, my lord. Even during penalty also, the dividend is not waived out from paying rent, my lord. The litigation ends. In support of my condition, my lord, I have filed this IA number 2736, my lord, wherein I have obtained the credit certificate from the treasury. This credit certificate is clear enough. The default period, my lord. Even during penalty of the litigation also, they had not continued depositing the rent continuously on each and every month.
and during dependency they have not paid off.
No, my lord, they have defaulted. Their credit certificate shows. They defaulted for so many months. Certificate is there, my lord, on record.
Which I
IA, my lord, 2736. Against this IA, my lord, no reply has been filed. My lord, IA 2976. 17.
2997
76, 17. 17.
279.
2796, my lord, 17. This IA was filed, my lord, for consideration of certificate development of default. Apparently clear, my lord, from credit certificate issued by the treasury authority.
What certificate?
Credit certificate, my lord. Credit certificate.
Credit certificate.
Showing deposit of rent by the respondents, my lord, before the treasury. And in, my lord, in the government revenue head of account number 844, head of account number, earlier it was 8443, now this has been numbered as 104.
That's all.
Yeah, Mr. Speaker.
Will reserve that.
My lord, they,
If Lordship,
I have-
permit, then my lord, tomorrow morning I will place some judgment. Full judgment.
no, tomorrow morning, you have right.
With copy to you, sir.
Two things I have.
You can just produce the judgment, but no, will conclude the hearing. No hearing.
No, my lord.
Yes.
I'm not going to argue.
The challenge I have filed in the court, those challenges were exhibited without objection. And so far to that effect, pending is there.
Okay.
And so far, my lord, the lastly submitted my learned friend that this 2796.
Yes.
Well, the 2796, your lordship may not consider this because no notice was issued and we have not filed any objection. Moreover, what is the prayer in this petition? Your lordship kindly see the prayer at page 10 of the petition.
Yes.
Paragraph 10. Order
No, no, it's
Hello.
okay. Since we have not taken cognizance of the IA by issuing notice. The averments may not be accepted.
Because in this IA, they prayed for judgment and decree for the area rent and compensation of the subsequent period. Without amendment of the plan, without the revisional court can grant it subsequent areas of rent.
Okay.
That amendment is too necessary. Without amendment, this type of petition cannot be entered.
Heard Brianna for the
The rent was claimed, my lord, in that place
Petitioner.
till eviction.
also heard AC Sharma senior counsel for the respondent number 1. There is an order from this court dated 25/4/2023 to proceed ex parte against the respondent number 2. Yes. Well, here have also been paid. Hearing is concluded. Will come.
Much.
My senior Mr. MP Chaudhary, is on late in another court.
Those matters are not revealed this court.
Lordship has already heard the matter from MP Chaudhary. He was Lordship has heard the matter. Now Lordship, myself and NCT is to give the reply.
No, we have not heard. They will speak today.
No, Lordship, earlier, before that, Lordship. It was Lordship heard.
No, we remember some hearings we have done, but we have heard it. We take it, don't put it. Let him come. Wait. One. Hearing.
Make this, it's an appeal under Employees Compensation Act, my lord. Awarded amount 2,47,140.
Paid by insurance company.
It's an injury case, my lord.
In a WC.
W.
Let us have a look at
Substantial question
were
of
framed on 6/8/2008. Do you have a copy?
whether
Whether
substantial question of law framed by the whether the injury sustained by the claimant not being one as specified in Schedule 1, Part 2 of the Workmen's Compensation Act 1923 and
and there being no evidence and finding at all to show that the alleged disablement of the claimant reduces his earning capacity in every employment which he was capable of undertaking at the time of accident, the learned commissioner was justified in granting compensation in accordance of the provisions of the section 41C2 of the Act. And second one is whether the medical practitioner having purportedly assessed the loss of earning capacity of the claimant at 50% without due regard to the percentage of loss of earning capacity in relation to the injuries specified in Schedule 1 of the Workmen's Compensation Act 1923, the learned commissioner has been justified in acting upon the state purported assessment and granting compensation under section 41C2 of the Act.
Second question, meaning whether the medical practitioner having purportedly assessed the loss of earning capacity of the claimant at 50% is the loss of earning capacity which has been rightly assessed. It is not the physical disability. It has to be connected to the earning capacity. That has been assessed. Then what about the rate of without due regard to the percentage of loss of earning capacity?
Your lordship, number one
Okay,
will,
doesn't matter. Yes, proceed. Whatever has happened has happened.
I read the judgment. Will.
Yes.
That this claim case has arisen out of a claim petition filed by Mohammed.
What are you reading?
Judgment. Judgment.
Judgment is it is 5/4/2010.
I put 2010.
5/4/2010 in what?
WC case number
7 of 2008.
2008.
By which Commissioner Tezpur.
Workers of Tezpur.
How much has been granted?
2,47,140.
With interest,
No, Mr.
12%. Payment from date of issue of the order. 12% from date of issue of the order.
If the insurance company failed to pay within 30 days,
Put that 7,000. With interest, the 12% from date of order.
from the date of the order,
Very conservative. Very conservative. From date of filing of the claim petition.
no, Mil, it's the injury case, Mil.
Doesn't matter.
Non-schedule injury, Mil.
He's been entitled to some compensation. That compensation, the entitlement comes related to the date of the accident, but at least reasonably it has been considered that the date of the filing of the application. Now, date of order. Date of order. What is this?
This claim case has arisen out of
What
a
was the nature?
injuries sustained by this multiple previous injuries on his left leg, hip joint, and other injuries on several parts of the body.
What has happened there? Fracture.
Fracture, Mil. Because it was a driver, Mil.
He was a driver. Okay, let us see.
This claim case arisen out of a claim petition filed by Mohammed Abdul Rafiq by praying for compensation under section 3 and 4.
Nobody has appeared for the other side.
Service is complete, Miller. This claim case has arisen out of a claim petition filed by Mohammed Abdul Rafiq praying for compensation under section 3 and 4 of the Workmen's Compensation Act 1923 from the opposite parties for the personal injuries sustained by him in a motor vehicle accident arising out of and in course of his employment under the OP number 1. The claimant's case in brief is that he used to work as a driver in the vehicle number so and so under the employment of OP number 1 for transportation of passengers. His monthly salary was rupees 4,000 per month and rupees 50 was daily allowances. He was aged 23 years at the time of accident. That on 35/2007, the claimant had boarded the vehicle as driver and was proceeding from railway station Guwahati towards Nuagaon, carrying with passengers, but on its way at Sanchua, while the claimant took his vehicle to left-hand side to give side to another vehicle coming from opposite direction, the vehicle knocked down the railway iron post and another vehicle had hit his vehicle at his back under Nuagaon police station at about 6 a.m. As a result, the claimant had sustained multiple grievous injuries on his left leg, hip joint, and other injury on several parts of the body. The claimant was sent to nearest hospital for treatment with other occupants of the vehicle by the police of Nuagaon PS traffic bunch, but he is not cured and has suffered permanent partial disablement due to the injuries. Soon after the accident, the claimant informed the vehicle owner about the accident and the injuries sustained by him, but he did not pay any compensation, for which he has filed this case claiming rupees 2,50,000 as compensation for his loss of earning capacity. The Hyderabad Police Outpost registered a case of the accident by Hyderabad TOP GDA number 848 dated 38/5/2007. It was also stated the vehicle number so-and-so was driven by the claimant having valid driving license by driving license number so-and-so issued by Nuagaon, Assam, and at the time of accident, the vehicle number so-and-so was duly insured with OP number 2 National Insurance Company Limited, Nuagaon branch, Nuagaon, Assam, by policy number so-and-so valid up to 24/5/2008. As the place of occurrence of the accident is within the jurisdiction of the Commissioner for Workmen's Compensation, Nuagaon, notices in the prescribed form A were served upon the Commissioner for Workmen's Compensation, Nuagaon, and the Government of Assam in compliance of the first proviso to Section 21 of the Workmen's Compensation Act 1923. They filed the case at Tezpur exercising its option under Section 21 on B of the Act. The case was registered as Workmen's Compensation case number so-and-so, and the notices were served to the parties accordingly. The OP number 1 received the notice and contested the case by filing his written statement. The OP number 1 has admitted the accident and of the employment of the claimant in his vehicle number so-and-so. He has also admitted that the vehicle was driven by the driver holding a valid driving license. The OP number 1 also admitted the salary of the claimant but denied the allowances, further denied the injury and treatment of the claimant. The OP number 1 stated that his vehicle was duly under insurance coverage with the OP number 2, hence denied his liability for compensation to the claimant. He expressed ignorance about the age and cause of the accident. He enclosed all vehicular documents, including the copy of the policy of insurance. The OP number 2, the insurance company has denied the employment of the claimant under the OP number 1 and his accident and injury in course of and out of his employment. The OP number 2 denied the salary and allowance of the claimant which was paid by his employee during his employment. The OP number 2 stated in para 16 of the written statement that they had no knowledge whether the vehicle number so-and-so was duly insured with the company at the time of accident. The OP number 2 has denied each and every averment made in the claim petition and has put the claimant to strict proof thereof. From the accident information report, it revealed that the above vehicle was insured with the National Insurance Company Limited by policy number so-and-so at Nuagaon branch, Nuagaon, Assam, valid up to 24/5/2008. And in column 3 and 7 clearly stated that the claimant was the driver of the insured vehicle and sustained injury in a motor vehicle accident on 38/5/2007 at Chanchuar National Highway 37 at about 6 a.m. and also mentioned the number of the offending vehicle. The case was then fixed for evidence and hearing. The claimant was examined in chief as PW1. The claimant in his examination in chief stated that he was appointed as the driver in the vehicle number so owned by Muhammad Safiqul Islam Chaudhary of Barwan Patti, Tezpur, at a salary of rupees 4,000 per month. He corroborated and repeated the other contents of the claim petition. He stated that as a result of the accident, his left leg got trapped under the gear level and his thigh bone was fractured. 2 passengers were also injured. The police brought him BP Civil Hospital, Nuagaon. The doctor applied plaster after X-ray at BP Civil Hospital, Nuagaon, and thereafter he took treatments at Tezpur Civil Hospital and from Dr. Dhrubajyoti Deka, an orthopedic surgeon of Tezpur. When he was not cured, he took treatments from Dr. Munin Barkatuke, retired superintendent of BP Civil Hospital, Nuagaon. He removed the plaster and advised him for physiotherapy of the left leg. The doctor advised him for better treatment at Guwahati, but due to want of money, he could not go for treatment. He also stated that because of his pain in leg with knee joint, he is not in a position to perform the job driver. He produced the following documents: Exhibit 1, Accident Information Report; Exhibit 2 to 16, Prescriptions; Exhibit 17 to 19, X-ray reports; Exhibit 20, Injury Report; Exhibit 21, X-ray plate; Exhibit 22, real in original copy; Exhibit 23, copy of notice under Section 10 with postal receipt; Exhibit 24, cash memo. He prayed for compensation as per law. In order to prove his injuries, the claimant examined Dr. Munin Borkatuke, retired superintendent of BP Civil Hospital, Nagaon as PW2. Dr. Borkatuke deposed on oath that he examined Mohammad Abdul Rafiq, aged 24 years, at his chamber on 28/6/2007 following an RTA of 38/5/2007 and found the following injuries: fracture of left femur with angulation, X-ray referred dated 38/5/2007, multiple abrasions seen on both the shoulder joint, swelling, healed, hematoma on the chest wall. He opined that the injury number 1 was grievous in nature and injury number 2 and 3 were simple in nature caused by blunt hard objects. He came with complaints of tenderness, swelling of the left hip joint and knee joint. POP was already applied on left leg. The patient was initially treated at BP Civil Hospital, Nagaon by OPT registration number 38344 dated 38/5/2007. He was suffering from restricted movement of the left leg. He examined the patient last on 18/12/2008 and found that he has difficulty in movement of left hip joint and left knee joint and could not walk properly. He developed chronic osteoarthritis on left hip and knee joint, for which 35% physical disability, which is permanent in nature, and reduced his earning capacity by 50%. And it will be difficult for the patient to do his earlier job due to the injury. He examined the patient clinically at the time of issue of the disablement certificate. He proved Exhibit 21 as his signature. This witness was cross-examined by the learned advocate for the OP number 2. In replies to the cross question, he stated inter alia that he is not an orthopedic surgeon and a medicine specialist can also treat fractured cases. He stated on cross that as per his advice, the patient did not go to GMCH for further treatment. He stated Dr. Dhubajyoti Datta is an orthopedic surgeon of Tezpur. Further, the PW2 stated that the patient is mentally fit. He denied that his treatment was aggravated the condition of the patient. He assessed the loss of earning capacity out of his disability, and he is authorized to assess disability and loss of earning capacity as a doctor. He denied all other suggestions. On conclusion of PW, that opposite parties were asked to adduce DW, but the opposite parties did not adduce any contra evidence in support of their denial plea by examining any witness nor brought on record any documentary evidence. As a result, the claimant has discharged his initial burden to prove his case by both oral and documentary evidence, which remained unrebutted due to absence of any contra evidence. Heard the arguments of the parties and perused the case record and the deposition of the witnesses and the documentary evidence such as police report, injury report, and other medical documents. Both the oral and documentary evidence have confirmed the pleadings of the claimants. Under the circumstances, it is proved that the claimant was a workman under the OP number 1 and he is entitled to compensation for the injuries and loss of earning capacity as assessed by a qualified medical practitioner defined under the Act, suffered by him in an accident which arose out of and in course of his employment. Since the vehicle was under insurance coverage with the National Insurance Company Limited, Tezpur branch, and since there is no evidence on record to show that the terms and conditions of the policy were violated, the OP number 2 will indemnify the OP number 1 and pay the compensation to the claimant on his behalf. The claimant deposed his evidence on record that he used to earn rupees 4,000 per month as salary, which is not excessive and conforms to the minimum wages fixed by the government. Hence, his monthly salary accepted as 4,000 per month for the purpose of calculation of compensation. There is no contra evidence on record to suggest that the workman did not get rupees 4,000 per month as salary. His age is treated as 31 years as per the date of birth recorded in the DL. Therefore, the compensation payable to the claimant is computed as follows: so and so rupees 2,47,140 Miller.
Yes.
Here, the injury sustained by the claimant is not a permanent partial disablement. He suffered the injury is temporary partial disablement.
Where is your with the part.
No, I have. It's the unwritten.
Just a-
Unwritten written statement. Please.
Yes, yes, yes.
Para 15, I have denied me.
Paragraph 15.
That it is also denied as stated in para 10 of the claim petition that due to the injury of the left leg of the claimant became physically permanently disabled and lost his earning capacity ability resulting from the motor accident.
What are your
Lord, here the injury sustained is not scheduled injury, and the injury sustained in multiple previous injuries on his left leg, hip joint, and other injuries.
Yes, yes. Yes.
And the injury sustained is in the nature of multiple previous injuries on his left leg, hip joint, and other injuries on several parts of the body.
Yes.
That type of injury has not reduced his earning capacity.
Now, it is sufficient question of law that these injuries are not as per the statute. Scheduled on part 2.
For amputation below shoulder.
Yes.
The injuries are not scheduled injury.
So he'll not get any compensation.
No, Milo. The compensation is the injuries are in the nature of temporary partial disablement. And in that case, the compensation has to assist in under section 4(1)(d) of the WSEC. Section 4(1)(d) of the WSEC. I am relying on the judgment of this honorable court. Lordship may kindly come to definition part of the Employees Compensation Act, Miller.
Yes.
2G, Miller.
2G.
Partial, your lordship, partial disablement. Partial disablement means where the disablement is of a temporary nature. Such disablement has reduced the earning capacity of a employee in any employment in which he was engaged at the time of accident, resulting in the disablement. This is temporary partial disablement. Temporary partial reduces his earning capacity in which employment he was engaged at the time of accident. He was
Yes.
engaged at the time of driving. Therefore, he cannot do the job of driving, but he can do other jobs too. And where the disablement is of permanent nature, such disablement has reduces his earning capacity in every employment of which he was capable of undertaking at that time, provided that every injury specified in so and so shall be deemed to result in permanent partial disablement. But the injury sustained by the claimant is temporary partial disablement. And the doctor has also in his evidence stated he cannot do the job of driver.
See, part to schedule 1, all the injuries will fall under 2G. But 2G is not only confined to part 2 schedule 1. 2G can have any other injuries. But it specified that if the injury under part 2 schedule 1, it will come into the definition of 2G. That is the meaning. Please read again.
Partial disablement means where
Means where the
Yes.
disablement is of a temporary nature,
Huh.
such disablement as reduces the earning capacity of the employee in any employment in which he was engaged
at the
at
time
the
of
time of the accident resulting in the disablement, and where the disablement is of permanent nature,
Hmm.
such disablement as reduces his earning capacity in every employment. If it's a permanent disablement, then he cannot do any other job.
any other work.
It is disability of temporary nature. Then such disability reduces the earning which he was capable capable of undertaking at the time, provided that every injury specified in part 2 schedule 1 shall be deemed to be permanent
Partial.
partial.
So therefore, the claimants sustained the nature of injury claimants sustained does not fall in schedule is are not scheduled injuries. Therefore, these injuries are not permanent partial disablement.
The provision is only to include the injuries in part 2 schedule 1 to come with the ambit of permanent partial disability.
Here,
It has not said that any other injuries cannot be of
No,
that nature.
the-
Those injuries have been specified that those would be treated as a permanent partial disability.
no, Miller. The definition is
Provided that every injury specified in so and so shall be deemed. It's a proviso.
with regard to loss of earning capacity. Miller, temporary partial disablement is partial disablement two types. Temporary partial disablement and permanent partial disablement. in case of temporary partial disablement, it reduces the earning capacity of an employee in any employment he was engaged at the time of accident. That means here in the claimant was the job of the claimant was driver.
Driver,
He cannot
it
do
was
the
a
job of
partial temporary disablement by which he could have given employment to other things. But if it was a permanent nature, then
he
other
cannot-
things also he could not have been done. Now you are trying to base your submission
on temporary.
on the first substantive question of law that this does not come within the ambit of Part 2 Schedule 1. Part 2 Schedule 1 is inclusive.
No, therefore, if it is not come in the part 2 schedule, then the injury sustained by the claimant is temporary partial disablement.
Yes.
Then in that case, the compensation assessed under section 41C2 will not come, my lord. 41C2.
Case, the
Uh-huh.
case
Where
where
permanent.
permanent partial disablement self-injury. In a case of an injury not specified,
Hmm.
such percentage but he is not being able to walk properly. What is the evidence of the doctor? He has he examined the patient on 18/12/2008 and found he has difficulty in movement of left hip joint and left knee joint and could not walk properly. Riverside doctor, Riverside the job for driver, in other jobs.
There is a specific evidence that he cannot do the job of driver, Miller. In doctor's evidence, Miller. In examination, the chief is said he will not be able to do his earlier.
Fracture of left and angulation. Reverse. He came competence tenderness swelling of left hip joint, knee joint. POP was already applied on left side. Restricted movement of left.
Examination, which is if there is a specific evidence that he will not be able to do his earlier job due to the injury. But there is no whisper that he cannot do any other job.
Where
In examination chief of the Dr. Miller.
KW2.
Hmm. First part of examination,
First,
last part.
not the
Earlier job.
earlier job.
There is no whisper that he cannot do any other job.
But there is also no evidence that he can do some other job. First, just read that the paragraph above that injury number one was reversed, while the other two what just above that.
Hmm.
Injury number one is reversed, while the other two were simple. Caused by one on a diagram. Typical
Movement.
in movement of the hip joint and joint. When was the accident? 2035, 2007.
Hmm.
After 1.5 years, when was examined, it was found that he had movement of joint and left joint of left leg. He could not walk properly. He developed chronic joint in the hip joint and joint. I assessed him. So this part cannot, the last part you cannot read of what has stated above. What was the first step? Not very high.
I'm relying on the judgment of this only.
So the 9 guilty.
Hmm.
Yes, which paragraph?
Paragraph number 15, 17, 18, 19.
Paragraph
Paragraph number 15, 17,
15, 17.
15, 17, 18, 19, 21, 22, 23, 24, 25, 27, 29, 34, 36, 37.
What not be finding?
You lost me paragraph 24, Milord. From the aforesaid discussion, it is therefore clear that while assessing the compensation under section 41C2, what the learned commissioner is required to find out is whether such disablement is of a permanent nature which reduces the earning capacity of the workman in every employment which he was capable of undertaking and not merely the particular employment in which he was engaged at the time. For instance, if a driver claims compensation contending that he suffers disablement of permanent nature because of the injuries sustained by him on his hands or legs, what is to be seen by the commissioner is whether such disablement reduces his earning capacity as driver or reduces the earning capacity in any other employment which he was capable of undertaking depending on his skill. The burden of proving the disability and the reduction of earning capacity is obviously on the workman who claims the benefit of the act. If the commissioner finds that though the workman's earning capacity has been reduced,
Okay, we'll proceed that. Completed
Appellant's advocate Mr. P. Sundi had to suddenly leave for home to get
Which
medical emergency. Mr. Item 16. Item 16. Mr. Sundi was here. He had to suddenly leave home. Medical. 16. For the respondent.
On a prayer May 27. Just after a week.
I got item number 3 to 6. Yes. Your Lordship, I had concluded my lord arguments, and your Lordship wanted to hear the NCT only, the last occasion, but perhaps the submission was made that my lord, the matter has to be passed over. Because my lord, I have completed my argument. Your Lordship will remember, your Lordship only wanted to hear the NCT.
That was it. Alakandi BH College.
That BH College matter. I'll be there, my lord. The previous occasion, my lord, I had made submission for about 2 hours. Your Lordship has completed it.
But the name of the matter?
Musabir Ali, I don't know. WBC 5221 of 2000. That's it.
Five double one.
Your Lordship wanted to, because your Lordship said that one instruction from the NCT will settle the matter. That is what they
Is they have the instruction?
But we already filed our
File your.
affidavit.
What is your instruction?
Lordship, affidavit is that Lordship, Lord, we have nothing to say about, because that's a judgment of dishonorable court. So we not overtake that judgment, Lordship. But fact is
Overtake.
that Lordship, Tapan Kumar Sinha, Lordship. But the fact is that Lordship, they have applied within the time law. So
But you just reference. We had once you
I'll be here, my lord. So,
maybe around 20 minutes by you, then we can. But would like to complete present here that there is a judgment pronounced, not only delivered. We have pronounced
thereafter, your Lordship.
not before. But just since we have heard, we like to complete. You just refresh. I think Mr. Kusam has also heard.
He was also hurt. But
It was wrong time back. We have to note. Just to dictate the judgment. How long will it take, madam?
Judgment, Timur, not judgment.
Hmm?
Only Timur, not judgment are accurate. There are 20.
I would like to will not have your matter. If you dictate your judgment, we'll have it after.
Regarding item number 22, my lord, I have no instruction, but the claimant is stated already award has
Award has been
complied.
complied with, my
I have
lord.
to take instruction.
Here for whom?
And for the claimant, my lord,
Item
here
number?
is one number 1,
Item number?
22,
Supply list.
Supply list.
supply list. My lord, the next matter only.
No, they are challenging it. Whether it's satisfied or not doesn't matter if we uphold their challenge.
My lord, she need to obtain some instruction regarding that. I have told her that I have instruction regarding the award, which has been complied with by the tribunal, my lord. But she told me that she will obtain certain instruction.
Madam, we have understood what you have said. But only complying with the order judgment does not mean that they can abandon the challenge. They can still maintain the challenge. If you have instructions not to continue, that's a different matter.
I have to take
But
instruction.
merely because the payment has been made, the challenge has become infructuous. It's not
My
like
lord.
there are legal issues involved. You can still say that we want to continue.
I have
But
to,
if you want to take some instructions,
I have to
but
take instruction.
matter of which year?
My lord,
2010.
2010. An award has been award has been passed on 2007, my lord.
Because 2010 matter.
My lord, she will obtain some instruction regarding that.
When?
Next,
Make a telephonic call.
next, next.
Make a telephonic call if you are not very interested in continuing. Inform us today by today itself. By
Today, next week, Milo.
next Tuesday.
Next week.
This court has been informed. You are not on record.
No, my lord, I'm on behalf of SK Talukdar, ma'am.
MSS Box Learned Council appearing on instruction of the SK Talukdar Learned Council for claimant respondent has submitted that the amount involved in this appeal, which was granted by the award in question, has already been released to the claimant. Full stop. Para. MS Roy, Learned Counsel for the appellant, accordingly submit that some time may be granted to enable her to obtain instruction with regard to further course of action. Considering that the appeal is an old one, a short motion is granted. Direct system on
Tuesday.
Tuesday.
Deeply obliged. sir.
Everything. Or take a quick counsel for petition. Counsel for the sole residence. Where the present application has filed. Next para. New para. It is the case of the petition that the petitioner was the defendant. Petitioners were the defendant in the title suit, which was instituted under Section 6 of the Act. Full stop. In the plain, comma, the present respondent, who was the plaintiff, had averred that a plot of land measured 2 katha, 10 lecture, was in the possession of the plaintiff, in respect of which land revenue was also paid. On the west side of the suit land, comma, the plaintiff had patta land, and therefore the said suit land was used for thoroughfare. The patta land were under dock number 225 and 20, which were in the name of the plaintiff. And his mother. It is the specific case of the plaintiff that on 21/6/2012, comma, the plaintiff was dispossessed by the defendant and in October 2012, comma, the defendant had posted concrete pillars on the land, resulted from the plaintiff had issued legal notice, followed by institution of the present suit. New pair. The defendant in their statement separately filed had contended that the plaintiff was never in of any part of the substance which is covered by Doc 220 has further been stated that the father of the was considered of land of Manuel Patra number 3 covered by Doc number 25 and 2, and he had transferred the possession of the land to the defendant number 1 on 12/3/1994 by executing a Kacha sale deed. Kacha deed and on sale deed the plaintiff and his brother were the defendant came in conflict of the land till 2012, and the plaintiff, in spite of having knowledge about the transfer of the land covered by Doc numbers 225 and 220, had got the name of the members of the family mutated in place of father. Full stop. In any case, it is the specific case of the defendant that he was continuous and good for this overt then and further averred that the plaintiff did not submit any document to show his position. Full stop. New para. The defendant number 2 in his petition had also stated that the plaintiff was never in possession of the plot of land covered by Doc number 2 within bracket 2, which was in front of the plot of land covered by Doc number 225 and 220. Full stop. New pair. The learned trial court, upon perusal of the plea, had formulated 9 numbers of out of those, the relevant issues would be issue number 5, 6, and 7. With regard to number 5, the learned trial court had come to a finding that the plaintiff was in possession since long over plot of land covered by dock number 220 corresponding to clause D 97. The learned court has also discussed the evidence of 5 numbers of deed and also the deposition of the deed who had mentioned about the other plot of land covered by dock number 225. With regard with regard to number 6, comma, the learned trial court had come to a point that the page was disposed on 21/6/2012, and according the issue number 8 with regard to entitlement for COVID, comma, the same was decided in favor of the new para. Three, A. Ganguly, learned counsel for the petitioners, has submitted that the finding arrived at by the learned trial court is perverse and the relevant materials of record have not been properly appreciated, and rather the judgment based on irrelevant materials and extraneous consideration. He submits that the learned trial court had taken note of Exhibit 4, which was a Jamapan, and a perusal of the would show that the same had contained only the signature of the last master, and there was no signature of the circle of. He further submits that the last master had deposed as CW5 on 58.4.2014, whereas the Exhibit 4 was also of the same date. He submits that the same raises a great deal of doubt, suspicion, whereas the learned counsel for the petitioner has also drawn the attention of this court to Exhibit 5, the Chitha, in which the name of the page was not there. Also, reference has also been made to Exhibit 6, the trace map, and has contended that the plot of land under docket number 25 and 20 are in the possession of petitioners and the suitment covered by docket number 220, which is the only access to the national highway. Is submit that the petitioners had purchased the plot of land under docket number 225 and 220 from the father of the petitioner by a Katha Sep dated 12/3/19, which was proved as exhibit of the state deed executed by the father of the plaintiff, namely Dimpeswar Sharma Put, had also not right. The plaintiff itself was a witness to the state dated 12/3/19 executed by his father, Dimpeswar Sharma. Sri Ganguly has also referred to schedule of the plaintiff to contend that on the east of the schedule of the suitlet, there was Sarkari land and annexed to he submit there was Sarkari land and annexed 50, and if at all the plaintiff was subject of the land inspection covered by docket number 2, there should have been a description in schedule which was not there. As regards the lossy receipt, the Ganguly found that while exhibit 1 is dated 15/10/2012, exhibit 8 is dated 17/10/2013, and neither of the receipts would show that prior date which this was set, the plaintiff was Sri Ganguly has according to the following question. For one, when how the plaintiff had done of the suit plan. The plaintiff has proved that he was settled in possession and not in fugitive or stray possession. Whether the plaintiff had that ability to establish that he was dispossessed. But in support of his submission, the London Council for the Petition has relied upon the case of Rame Koda, reported 2000 complete SPR 85. New para. For contract,
Lordship, if your lordship, for one, yesterday I did not come on the basis of that receipts, Chaudhary. He said 12 and 30. In fact, the 12, if you can, lordship can verify, 12 is for the year, 11, 12, 13 is for the year, 12. So normally after the year, the payment is, which normally we all do.
for contract, Sri Mannan, London Council for the respondent, open bracket plaintiff, bracket close, has submitted that the issue is only with regard to dispossession of a party who was in possession for that. And in a suit of instant nature instituted under section 6 of specific British Act, given title will hardly have any role. He submits that the case projected by the respondent has been was duly established by 7 numbers of PW. He submits that though the plot of land covered by DAG number 225 and 2 was sold to the petition by other, the said sale was not concerning the present suit land, which is covered by a separate DAG named DAG number 220. New paragraph. Sri Mannan has highlighted that after discharging their initial burden, the initial burden by the plaintiff with regard to the fact of disposition of the owner's defendant. The defendant who had deposed as DW in her evidence did not state that she was in possession of the suit land covered by Doc 220. By drawing the attention of the court to the plain of the learned counsel has submitted that was specifically stated that the plaintiff was continuous possession of children, and this connection he has referred to paragraph 7 of the plain. Numeral. The rival made by the learned counsel for the parties have been duly considered, and materials is put, including the LPR, have been examined. The Sri Manan also submits that though an argument has been made with regard to policy decision by continuing the same to be after the date of possession, he submits that Exhibit 1, though dated 15/10/2012, was for the relevant, as it is only after expiry of the period that such policy is paid. He further submits that the burden on part of party alleging is to be discharged with regard to the relevant period, namely the date of possession, and earlier period cannot necessarily paragraph. In the instant case, though Sri Ganguly, the learned counsel for the petitioners, may be correctly contending that the documentary evidence may not fully support the case of the respondent, comma, the opinion of this court, comma, the crucial issue is the issue of possession, and such fact can be proved by oral evidence only. As indicated above, even a rightful owner of a plot of land having valid title has to take due course of law to evict any unauthorized person who is in occupation. And law does not permit even such right owner to forcefully evict a person in possession. Therefore, even ignoring the documentary evidence exhibited on behalf of respondent, namely the Jamaban and the Chita, the orally will adduce on behalf of plaintiff, it still can from which the fact of the plaintiff being in possession of the sultan who was dispossessed on Twenty-one 6/2012 appears to have been established in the proceeding. New paragraph. A revisional court exercised powers under section 115 of is not an appellate court and therefore cannot give evidence on record. The interference by is a circumscribed one and only upon certain conditions, interference may be made, and those conditions have been made above. The opinion of the impugn judgment does not suffer from a jurisdictional error or from a irregularity which requires any interference by the court. In the case of Rame Gouda relied upon by petitioners, it has been laid down that the principle of possession has been laid down, wherein possession has been held to mean a substantial possession and not the possession of a trespasser. There is absolutely no dispute with the proposition laid down, but in the instant case, that the respondent plaintiff was able to establish his position over the sultan till the crucial date, 21/6/2012, when he was put to disposal. In view of the above, courts of the opinion that no case for is made out according to the evidence the LCR 10 back.
But sir,
Yes, madam.
There are 24 of the judgment. There are 24.
Yes.
From the opposite discussion, it is therefore clear that the
Which para?
para 24. Para
24.
Para 21, 22, it was discussed what is permanent partial disablement, what is temporary partial disablement. 21, 22, was 23 was discussed below. May I read from paragraph 21?
Yes. Paragraph 21.
It was discussed what is permanent partial, temporary partial disablement.
Let us read.
From the paragraph 21, from the language used in section 21G of the Act and in the context, the word any used therein indicates that the legislature has meant any employment as the employment in which the workman concerned was engaged at the time of accident resulting in the disablement. That means the employment specific which the workman had performed. A disablement could be said to be temporary partial disablement if such disablement is of temporary nature and has reduced the earning capacity of the workman in the employment in which he was engaged at the time of accident, resulting in the disablement, and in the instant cases as drivers. It would appear from the definition of partial disablement in section 21G of the Act that to constitute permanent partial disablement arising out of an injury not specified in part 2 of Schedule 1 of the Act, it must be such disablement of a permanent nature which reduces the earning capacity of the workman in every employment which he was capable of undertaking at the time of accident, resulting in the disablement. The legislature has used different languages while defining the temporary partial disablement and permanent partial disablement. To constitute the permanent partial disablement arising out of non-scheduled injury, it must be proved by the workman concerned that the disablement resulting from the injuries has incapacitated him in performing any other employment which he was capable of undertaking apart from the employment in which he was engaged at the time of accident. It, however, does not mean all sorts of employment, but means such employment which the workman is capable of undertaking at the time of accident, depending on the nature of skill possessed by the workman and the skill required for the purpose of such employment. To assess the amount of compensation payable to a workman and calculating the loss of earning capacity within the meaning of the Act, the possibility of the workman discharging a different type of job must be borne in mind. However, every injury specified in Part 2 of Schedule 1 shall be deemed to result in permanent partial disablement.
This is what we are emphasizing. That if it's an injury falling under Part 2 Schedule 1, that is a permanent, but there may be injuries other than these also, but to prove that you need to establish, but to have that benefit.
Workman has to establish.
Yes.
It would appear next. It would appear from the definition of total disablement in section 2(1) of the Act that it means a disablement, whether of a temporary or permanent disable nature, which incapacitates the workman for all work. That is permanent total disablement, which he was capable of performing at the time of accident. However, the permanent total disablement shall be deemed to have been resulted from the specified injuries specified in Part 1 of the Schedule 1 or from any combination of the injuries specified in Part 2 thereof, where the aggregate percentage of loss of earning capacity as specified in Part 2 against those injuries amounts to 100% or more. To constitute temporary total disablement, the disablement must be for a temporary period and incapacitates the workman from performing all work which he was capable of at the time of accident. Similarly, to constitute permanent total disablement, it must be of permanent nature and incapacitates the workman from doing all work which he was capable of doing at the time of accident. However, with the exception as provided in the proviso to section 2(1)(I) of the Act, the language used by the legislature is defining temporary partial disablement, permanent partial disablement, and total disablement are different. From the aforesaid discussion, it is therefore clear that while assessing the compensation under section 4(1)(c)(2), what the learned commissioner is required to find out is whether such disablement is of a permanent nature, which reduces the earning capacity of the workman in every employment which he was capable of undertaking, and not merely the particular employment in which he was engaged at the time of accident. For instance, if a driver claims compensation contending that he suffers disablement of permanent nature because of the injuries sustained by him on his hands or leg, what is to be seen by the commissioner is whether such disablement reduces his earning capacity as driver or reduces his earning capacity in any other employment which he was capable of undertaking, depending on his skill. The burden of proving the disability and the reduction of earning capacity is obviously on the workman who claims the benefit of the act. If the commissioner finds that though the workman's earning capacity has been reduced in the employment in which he was engaged at the time of accident, but has not been reduced in respect of other employment which he was capable of undertaking at the time of accident, depending on the skill, the compensation cannot be assessed under section 4(1)(c)(2) of the Act. In that event, the compensation has to be assessed under section 4(1)(d) of the Act. The workman, however, by adducing acceptable evidence, can establish that because of the injury, his earning capacity has not only been reduced in respect of the work which he was performing before the accident, but also in respect of any other employment, depending on his skill, and also the skill required for other work which he was capable of undertaking at that time, in which event it would amount to permanent partial disablement, provided the disablement is of a permanent nature. Now, your lordship may come to paragraph number 37.
Yes.
Thirty-six.
Seven.
36, 37.
Yes.
In all the WC cases registered on the basis of the applications filed by the workmen for awarding compensation, the owners of the vehicles concerned have their in written statements filed admitted that they removed the workmen from service as they are incapable to drive the vehicle because of the injuries sustained. Evidence on record as discussed, however, do not suggest that the disability suffered by the workman has reduced their earning capacity in every employment which they were capable of undertaking at the time of accident, that is the employment other than driver, so as to constitute permanent partial disablement within the meaning of the Act, though there are evidences on record such disablements have reduced their earning capacity in the employment, in these cases as driver, in which they were engaged at the time of accident, resulting in disablement. That apart, it appears from the evidence on record that such disablement is of a temporary nature. The workmen concerned did not lead any evidence to show that the disablement suffered by them have reduces their earning capacity in every employment which they were capable of undertaking at the time of accident, apart from their employment as drivers. Therefore, the workmen have suffered temporary partial disablement within the meaning of the Act. As noticed above, compensation under section 4(1)(c)(2) can be assessed only in the event of permanent partial disablement results from the injury caused to the workmen. In case of temporary partial disablement, whether total or partial, which results from the injury caused to the workman, he is entitled to compensation to be assessed under section 4(1)(d) of the Act, that is half monthly payment of the sum equivalent to 25% of monthly wages of the workman to be paid in accordance with the provisions of subsection 2. There is no dispute in these cases that the disablement cause lasts for a period of more than 28 days. The workman concerned would therefore be entitled to half monthly payment under section 4(1)(d) of the Act. subject of courts to review that may be done by the learned commission under section 6 of the Act. The monthly wages of the workman consists on MFA number so and so in every half month under section 4(1)(d) to be paid in accordance with the subsection 2 of section 4 of the Act for a period of 5 years from the respective dates of accident, that is with effect from 25/11/2004. There were three cases, 5/4 and 7/11/2004 respectively, subject to the orders that may be passed by the learned commission under section 6 of the Act in the event of fulfilling the conditions to exercise such power. There is also no proof of any condition stipulated in proviso A and B of subsection 2 of section 4 of the Act in these cases. The learned commission is therefore directed to work out within 1 month from the date of appearance of the workman and insurance company the total amount due and payable to the workman till date under section 4(1)(d) of the Act, and to release the same to the concerned workman out of the amount deposited by the insurance company before him after deducting the amount already paid pursuant to the interim order passed by this court. The said amount shall carry interest at the rate of 12% per annum under section 4(a)(3)(a) of the Act. The workman shall, apart from the said amount, be also entitled to half monthly payment under section 4(1)(d) of the Act till completion of the period of 5 years from the date of accident, which shall be paid to them in accordance with the provisions of the Act. The parties entitled to file application under section 6 of the Act seeking review of half monthly payment are at liberty to file the same, subject to fulfillment of the conditions stipulated therein. It is, however, made clear that if the amount deposited by the insurance company has already been paid to the workman, which may be in excess of their entitlement, the same shall not be recovered from the respondent's workman. Such deduction has been issued keeping in view the financial condition of the workman concerned. The workman and the insurance company are directed to appear before the learned commission on so and so. Just remand back, my lord.
But the learned court has held that 4(1)(d) cannot be ignored. Even if there is no permanent person, 4(1)(d) of course have to be taken, and the amount granted can be reduced as per thing with 4(1)(d).
4(1)(d). Here is also the claimant is entitled to get compensation under section 4(1)(d).
How much will be the difference in the amount?
I have not calculated.
Have to calculate. So if it is a minor difference, then probably accident was when?
Accident took place on
Accident was on 2007,
2013.
30th of May.
We have deposited 50% of the awarded amount before this registry.
The driver, thereafter, where is he working now? Working.
We have taken paper publication, but nobody appears.
Taking into account the amount involved here on interface. But we have made a point of we'll consider that we have done a similar thing yesterday also. And these matters are not again returned. Heard. For the appellant. Insurance company which has preferred the present bill under section 30 of Workmen Compensation Act with open to present Employees Compensation Act with prospect. So, state appeal has preferred against judgment and award dated 5/4/2010 passed by the learned commission, Workmen Compensation, is in WC 7 of 2008, by which Assam with 2,47,140 as death has been awarded. Full stop. New pair. This court by this with by the order dated 16,008 has formulated the following two substantial questions of law. New pair. Extract from order dated new pair. The claim was instituted by the respondent number one has claimed under section 3 and 4 of the Act for injuries sustained by him in a motor vehicle accident arising and in course of his employment with the respondent number 2. It is the case of the claimant that used work as a driver in a vehicle bearing number AS 12 capital E class 039 open bracket cruiser bracket cruiser under the respondent number 2 for transporting passengers and was paid a monthly salary of 4,000 per month and a daily allowance of rupees 50. Also, the claimant has stated that he was 23 years of age at the time of the accident, which had occurred on 30.05.7 at Saint Croix, the district of Nagaon. In the said accident, the claimant had sustained multiple previous injuries on his left leg, hip joint, and other parts of the body. Full stop. The claimant has also submitted that he had suffered permanent partial because of the accident and has no compensation from the instant application was filed with a claim of 2,50,000. The connected police case was registered as Hoibergaon POP GDE number 848 dated 30/5/2007. It is also the case of the petitioner claimant that the vehicle in question had a valid insurance cover. Repair. The present respondent number 2, who was the OP number 1, open bracket owner, bracket close, had appeared in the before the commission and had filed written statement wherein most of the factual aspects were admitted. Also, there was clear admission of the claimant being an employee, his salary, full stop. It was only the aspect of daily allowance which was denied, and other aspects were most admitted. New pair. The insurance company, present appellate, which was arranged as P number, had, however, denied the claim, including the fact of employment. New pair. The claimant had adduced evidence as PW1 and the second witness PW was Dr. Punit Borkotok, the physician who was consulted by the petition, by the claimant, and who had also issued the disability certificate. In the evidence recorded, it clearly came out that the claimant was not in a position to perform duties as driver due to the injuries sustained and and the pain he was suffering on his left leg and hip. The contesting parties for the commission, however, did not adduce evidence. New para. The learned commission, as indicated above, after hearing the parties, had made the award for an amount of fees 2,47,140 with interest at the rate of 12% from the date of issue of the order. New para. Mr. Roy, the counsel for the appellant has submitted that though the compensation as assessed directly paid by invoking the provision of section 4(1)(c)(2), comma, the conditions precedent are apparently absent. By referring to Schedule 1 of the Act, comma, the Land Council has submitted that none of the specified injuries would cover the injuries alleged to have been suffered by the claimant in instant case, and therefore the aforesaid provision of law would not have been taken forth while making yes for compensation. The Learned Council has also drawn the attention to the cross-examination part of the PW2, Dr. Munir Kolkata, who admitted that he was not an orthopedic surgeon and yet had issued the disability certificate. The Learned Council contends that a disability certificate can be issued only by an authorized body and not by a doctor on his doctor who had private examined the patient. The further submits that to be eligible and entitled for compensation under the aforesaid provision of section 4(1) D2,
41D.
41D, comma, there has to be permanent partial disability which does not appear to be present in the Learned Council has also relied upon the case of National Insurance Company Limited versus Vimal Nathai, reported 2009, open bracket 1, close bracket GL 370. The same case, comma, this court on notice that the conditions under section 41D, 41C was not present and remanded the matter for a consideration under section 41D. Let us see that
41C2.
none of the respondents have appeared or contested this appeal, and in this connection, reference can may be made to the order dated 13/12/2007 passed by the court, wherein service upon respondent numbers 1 and 2 was treated to be complete. The contention advanced by M.S. Roy, the learned counsel for the appellant insurance company, has been duly considered, and the material placed put forth, including the LCR, have been examined. This court has noticed that though two substantial questions of law were framed in this appeal, none of the points leading to formulating such substantial questions of law were raised by the present court commissioner. So far as the provision of law contained in section 4132 of the Act is concerned, there is not even a reference in the written statement filed by the insurance company, which also did not adduce any evidence. With regard to the second substantial question of law regarding the loss of earning capacity, this court has noticed that though there was no specific issue raised, the claim of having suffered such loss of earning capacity can be inferred from questions put to the doctor in the cross-examination. Be that as it may come, since the questions, substantial questions have been formulated, which are questions of law, this court would examine the state question in the context of material available on record. M.S. Roy, the learned counsel for the appellant, while referring to the provisions of section 4(1)(c), has also referred the injury specified in part 2 of schedule 1 of the Act the language employed in the statute would, however, make it clear that while the injuries specified in Part 2 of Schedule 1 are to be termed as permanent partial disablement, comma, there is no, these such injuries are not exclusive in nature, and the requirement in law is to establish that the injury suffered is of, if who suffered would cause permanent partial disability. So in the instant case of the learned counsel may be right in consenting that the certificate of disability has not been issued by an appropriate authority as prescribed under the law. However, this court has noticed that PW2, which who had examined the claimant, was produced, had adduced evidence as PW2, the doctor had adduced evidence as PW2, and in such evidence, he had stated that on examining the patient on 18/12/2008, it was found that he had difficulty in movement of left hip joint and left knee joint and could not walk properly. It was further deposed that the claimant had developed chronic osteoarthritis on the left hip and knee joint, resulting in physical disability. Therefore, it is not a case where such disablement was claimed on the basis of a certificate, but the doctors who had examined the claimant had also deposed for learned commission. This court has also noticed that the accident was of the year 2007 and more than 16 years have passed, and the amount awarded was rupees 2,47,140, which cannot be said an exorbitant amount. So, this court has also noticed that the claim regarding salaries and employment was admitted by owner who was implicated as OP number 1, the claim, it is also. This court has also seen that the interest awarded of 12% is from the date of issue of the order and not from the date of action. Therefore, taking into consideration the efforts back and also keeping in mind the object of statute in hand, which is benefited from this court is of the view that interference on technical ground, which will not make a considerable difference in the amount awarded, would not be necessary. More so when the amount involved is not negligible. In view of the discussion of the instant appeal is held without merit and according to this. At this stage, MS Roy, the learned counsel, has submitted that an amount of 50%, that 50% of the awarded amount was deposited for the
Register of the Sonora. Register of the Sonora.
registry of this court. Has it been released,
Claimant has not prepared.
Uh,
Claimant,
which perhaps has not been withdrawn by payment from that, according to the appellant, are directed to deposit the remaining, the balance report, which however would carry interest at the rate of 12% in accordance with order, in terms of the order of the learned counsel. Sent back to LPA. Yes.
I think your lordship would like to hear NCT.
Just refresh. We have
The issue in my writ petition is, my lord, I have challenged the validity of the BA degree of the respondent number 7 on the ground that he has obtained
you
it
are
from
arguing
5221 of 2022,
Mutabir,
Musabbir Ali.
whether here of respondent number 7 is valid.
Yes, my lord.
That is the question.
That is the issue. And the reason for invalidity that I have urged.
You are
is
the
that-
principal of Ballester HS School.
Yes, my lord. Secondary.
And on an earlier occasion, the BEd of respondent number 7 was held to be invalid.
Yes, my lord.
That was the subject matter of 3-5 351 of 2021.
3551.
And the matter was remanded by this court on 9/8/2021,
Yes, ma'am.
and the remand was on two issues. Correct?
On 17/8/2021, is my lord 71. The petitioner was allowed to assume charge. Holding that, my lord, my degree is valid. Now the order challenges
No, no,
at
no.
page 7.
17/8 we had we struck off by something wrong. 17/8.
17/8 is at page 71.
71. We wrote and we struck off. There was
Right.
some- Why 71? Isn't it relevant? 71?
71 is an order dated 17/8/2020.
Right.
My lord.
Isn't it relevant? I think it's relevant.
My lord, I was given an appointment, but the charge was not handed over. Then pursuant to this order, then the charge was handed over.
17/8 charge was handed over. But
My
this
lord.
is by director.
My lord,
Director secondary.
my lord. The remand order is at page 65.
Or just 71 by director. Secondary education. What did it do? 71?
17 was the, my lord, order by the
Okay.
director allowing the petitioner to assume charge because, my lord, I was not handed over charge. Although the IS directed,
Allowing you to presume charge.
yes, my lord.
Allowing.
And I am functioning my as the, my lord, principal. The order of this honorable court,
What is 73?
73 is the, my lord, the order which is under challenge. This has been passed by the additional secretary.
72/6/2022.
Yes.
Under challenge.
Yes, my lord. This is under challenge. Government here. Your lordship may like to read one paragraph of the, my lord, of the judgment at page 68. That will be relevant, my lord, for determining the issue. And this is precisely the ground before your lordship now also.
This 73 has taken recourse to Pranita Sharma.
Yes, ma'am.
Let us pick the 73.
Regarding compliance of court order dated 9/8/2021, WPC number so and so. With reference to the subject cited above, I am directed to inform you that the Honorable Guwahati High Court in its order dated 9/8/2021 in WPC 3551 of 2001, the matter regarding appointment to the post of regular principal of Balestra Higher Secondary School was remanded back for a fresh consideration by taking into account that in the Protima Sharma judgment, the last date for submission of application to NCT had been held to be 18/8/1997, and any institute which makes its application prior to the said date, the B.Ed degree obtained from such institute would be valid degree, but at the same time, determination would also be required whether the institute which has submitted its application prior to 18/8/1997 was in existence. This is the, my lord, part I am
harping on, as on 17/8/1995, when the NCT came into force. Accordingly, a report was called from the regional director, NCT 15 so and so addressed, and subsequently the regional director has submitted a report on 16/11/2021, wherein ERC NCT had informed that an application for grant of recognition for B.Ed course dated 12/8/1997 was submitted by the institution, namely Dr. Shashi Bhushan Institute of Education, Hailakandi B.Ed College, RP Road, Hailakandi, diary number such and such, dated 21/8/1997. The matter was also referred to the Judicial Department for the legal views, and the legal LR Commissioner Secretary Judicial submitted his legal views. In the instant case, the institute, namely Dr. Shashi Bhushan Institute of Education, had applied to NCT on 12/8/1997, and therefore the B.Ed decree of the Sri Musbushuddin was, who was a student during the session 96/97, it will be, and passed out in 1997, is valid from legal point of view.
Who is Mokuruddin?
I'm doing the private response. Now, your lordship will kindly notice, my lord, although in the first part, in the first paragraph, my lord, the additional secretary has taken note of the fact that in the last sentence, it will be required whether the institute which had submitted its
Mokuruddin
application.
is R7.
Right.
R7.
Right.
Yes.
Here, my lord, in the last sentence, although it was noticed by the additional secretary that degree obtained from such institute would be a valid degree, but at the same time, determination would also be required whether the institute which has submitted this application prior to 18/8/1997 was in existence as on 17/8/1995 when the NCT came into force. So this aspect was not considered. In fact, my lord, that was the case in the, my lord, in the writ petition. If your lordship kindly reads in the judgment, my lord, at page 68.
Yes.
Paragraph 11, last two sentences. Mr. So-and-so learned counsel for the respondent number 6, on the other hand, submits that NCT Act came into force on 1/7/1995 and the appointed date is 17/8/1995. And the date for submission of application for recognition was extended up to 18/8/1997 only in respect of such institutes which were in existence on the date when the Act came into force. The subsequent date of 18/8/1997 would not be applicable in respect of such institutes which came into existence after the appointed date of NCT Act. And that is precisely my case, my lord. Your lordship may also read in the paragraph 12. Mr. Saikia raises an allegation that Dr. Shashi Bhushan Institute of Education was not in existence as on 17/8/1995 when the NCT came into force, inasmuch as it was established on 31/12/1995. So these dates are important, my lord. And this issue was not my lord, discussed or decided in the, my lord, judgments that have been placed by the, my lord, other side. This was not an issue in those writ petitions. In fact, my lord, this issue has fallen for consideration before this honorable court. In this
You,
case,
can we just clarify? Where is Was it different fact?
My lord, we have given a compilation. There it is there.
You want to, if we have recorded correctly, the Act of 1990 came into force from 1/7/1995,
My lord.
right?
Yes, my lord.
And the appointed date was 17/8/1995.
My lord.
You have contended that this particular institute, Sasibhushan, was established on 31/12/1995.
My lord.
That is after the appointed
After
date.
the appointed. So on the
And
appointed.
the college had applied for recognition in
Yes.
2000 was recognized. That's
Yes.
a different matter.
Yes.
Now, respondent number 7 had appeared for GATE exam June 1997.
June. Yes, my lord.
June 1997. That means after the appointed date.
Yes.
Before the appointed date, but the college applied for recognition after the appointed date.
After.
And that is a provision in section 14
Yes, my lord.
for existing.
Existing institute.
You want to contend that this particular college will not fall within the definition
Existing.
because of the time factor.
Yes.
What is the time factor?
Section 14, my.
Yes.
A recognition of the institution offering course or training in teacher education.
What about the existing institution? Where is the qualification? You have said something about existing, provide there is a proviso for it.
Yes, my lord. Immediately after the first paragraph.
Yeah, provided.
Provided that an institution offering a course or training in teacher education immediately before the appointed day, that is 17/8/95, shall be entitled to continue such course or training for a period of 6 months if it has made an application for recognition within the said period and until the disposal of the application by the regional committee. So this is, my lord, this proviso is for existing institutes.
What is the requirement? Therefore, an institution offering a course of training immediately before the appointed date. Appointed date we have is 17/8.
17/8/95.
That means they were imparting education prior to 17/8.
Yes. And if it has made an application for recognition,
and this institution itself was established after
the appointed,
it was not an
it was not an exception. Therefore, this provision of extension of time, because they are, my lord, harping on the extension of time.
So his B.Ed degree obtained in 1997 was at a period when this institute was yet to be recognized.
Yet to apply for a revocation. Yet to apply for it. Appeared in the examination in June and applied for recognition in December. August, my lord, 12 August.
Even there is a proviso. There are many things provided that the institution offering a course immediately before the appointed date. That
Yes.
means prior to 17/8/1995.
Yes.
Immediately prior.
Yes.
It was imparting. Shall be allowed to continue such course or training for a period of 6 months.
6 months.
And if it is made an application and this period can make the application.
Yes.
That means till 17/8, 9, 10, 11, till February 17, 1996 an existing institution could have applied.
Applied.
Number one, here the recognition was applied on 17/8/97.
Yes.
12/8.
12/8/97.
12/8/1997.
12/8/97.
Time granted to apply.
So that is for, my lord, existing institution. And the institutes which were established subsequent to that, they have to apply for recognition first. Then, my lord, after the recognition is given, my lord, they, my lord, admit students and impart training. And section 17, subsection 4 may also be related.
And you want to have contended that during the date of recognition, date for application of recognition is after his appearance in the exam.
Yes.
He appeared in June 1997 and the institution applied in August 1997.
Your Lordship may kindly have a look at section 17 also.
17.
Section 17, subsection 4.
Yes.
If an institution offers any course or training in teacher education after coming into force of the order withdrawing recognition under subsection 1, or where an institution offering a course or training in teacher education immediately before the appointed day fails to neglect to obtain the recognition or permission under the Act, the qualification in teacher education obtained pursuant to such course or training or after undertaking a course or training in such institution shall not be treated as valid qualification for purpose of employment under the central government, any state government or university, or any school, college, or educational body aided by the central government or the state government. Now my submission will be, my lord, when the petitioner appeared in the examination, that
Petitioner note,
sorry, respondent number 7 appeared in the examination, recognition was not applied, and what will happen in such a case, that can be, my lord, gathered from section 16. Affiliating body to grant affiliation after recognition or permission by the council. Notwithstanding anything contained in any other law for the time being in force, no examining body shall, on or after the appointed day, grant affiliation, whether provisional or otherwise, to any institution, or hold examination, whether provisional or otherwise, for a course or training conducted by a recognized institution, unless the institution concerned had obtained a recognition from the regional committee. So the examination also could not have been held.
And since the reference to section 14 has been made,
Right.
that will also include give the liberty for which were existing.
And but in fact, my lord, that timing,
was 16,
that 6 months time has
Not-
been,
16 though it started with constantly cross, not it.
Yeah.
It has made it subject recognition of 14 may include in institution which was there, pre-existing institution prior to the appointed date.
yes, yes.
With the further condition that such application to be made within 6 months.
That has been extended subsequently, man. Because there are many requests made, no, my lord, the forms have been, rules have been framed. These are the grounds. On that, my lord, the time was extended. So that extension, time extension will not cover the, my lord, my lord, the institute which are not in. That is. And I have, my lord, relied on certain decisions that compilation I have placed, my lord.
Yes.
I will not take your lordship time reading all those judgments, but may I indicate the, my lord, relevant paragraphs and the point?
Yes.
The first decision 2013-1 SCC, National Council for Teachers Education versus Venus Public Education Society. The point which, my lord, I'd like to place is that without recognition from NCTE, students cannot be admitted. That your lordship
Which
will
one?
2013-1 SCC.
Venus,
National Council, the
Venus
NCTE,
public,
Venus Public. Right. Relevant paragraph will be,
33.
I think I have already noted that. Or your lordship may have.
This date on a studied scrutiny,
Page 33, my lord,
on a
paragraph.
studied scrutiny. Paragraph
No, my lord, paragraph 35.
35.
Page is 33. My
Yes.
I mean the,
On the last line,
now, to the last planned submission of the learned counsel for the appellant, it is urged by him that the NCT had procrastinated its decision at every stage, and such delay was deliberate, and therefore the society was compelled to admit the students and impart education, regard being had to the fact that there were really no deficiencies. As has been laid down in many pronouncements of this court, that without recognition from the NCTE and affiliation from the university examining body, the educational institution cannot admit students. An educational institution is expected to be aware of the law. The students who take admission are not young in age. They are graduates. They are expected to inquire whether the institution has recognition and affiliation. If we allow ourselves to say so, the institution had given admission in a nonchalant manner. Possibly its functionaries harbored the idea that they had incomparable fertile mind. The student who had taken admission possibly immersed with the idea that ignorance is a bliss. It is also necessary to state that the institution had the anxious enthusiasm to commercialize education and earn money, forgetting the factum that such an attitude leads to disaster. The students exhibited tremendous anxiety to get a degree without bothering for a moment whether their effort, if any, had the sanctity of law. Such attitudes only bring nemesis. It would not be wrong to say that, on the contrary, both of them were expected to be Argus-eyed. The basic motto should have been transparency. Unfortunately, the institution betrayed the trust of the students, and the students, in a way, atrophied their intelligence. The second decision I'm relying, my lord, is Muktaram Deka. These are
Greek character.
my lord. These are
The expression. These are all Greek character.
yes, my lord. That's why our pronunciation becomes a little difficult.
Better not to say anything more. Because this is all Greek to us.
Yes, my lord. Actually, the language, the sentence, my lord, everything else is Greek. In fact, my lord, law was also a little Greek till the other day. The second decision.
By the way, do you know what does the Greek say? What is the equivalent expression? is all Greek to me. What will a Greek say? No, it's a valid
I don't know, but there may be one.
we'll discuss some other day. There is a
There should be another
there is
proof that. I'm not aware of that.
Greek says it's all Chinese too.
It is Chinese. So it's the same thing for us, my lord, Greek or Chinese.
Doesn't make any difference.
Then in this decision also, my lord, our High
The
Court,
next one,
Muktaram Deka.
our High Court,
Yes, my lord.
Para 11, 12, 13.
11, 12, 13, my lord. The point is that without recognition, it is difficult to accord legitimacy to the B.Ed degree.
Correct.
Page 37.
Here also TMC University was there.
Yes, my lord.
Yes, next.
Next is, my lord, year 2007, Supreme Court 2588, State of Odisha versus Prasanta Kumar Sahu. The point there is, my lord, even if a policy decision taken by the state in exercise of jurisdiction under Article 162 would be subservient to recruitment rules framed by the state under Article 309. For deciding the issue, maybe, my lord, this decision may not be very relevant, my lord. I had brought this, my lord, on the broad principle. Prasanna Kumar Sahu, page 44.
Then Rajasthan State.
Rajasthan State, my lord. My lord, this is on the principle that, my lord, because here naturally a sympathy comes to the persons, my lord, who have taken this B.Ed degree without there being recognition. So, my lord, sympathy and equity, this may be, my lord, in favor of the persons who have obtained this degree. But the Honorable Supreme Court has said that there is no equity in restitution against the law declared categorically by the court, and no principle of estoppel involved in in that particular. Relevant page, paragraph is, my lord, paragraph 19. 19 that your lordship will find at page 56.
Now, where is the question? Where is the portion regarding equity and sympathy?
If I may read, my lord, paragraph 19.
19 is a short paragraph. So that's there.
Yes, my
19 is not there.
executive instructions which have no status quo cannot override the law. That is what I discussed a little earlier regarding equity. That is, my lord, discussed in a better way in the next decision I am relying, my lord. At the D. Navachandra and Company. Page 70, it translates to 66. Paragraph 26 at page 66. May I read that, my lord? Paragraph 26. Before parting with the case, certain factors must be noted. The diamond exporters and dry fruit exporters have their full round in this court. Speaking entirely for myself, my conscience protests me that the When thousands remedialist wrongs await in the queue for this court's intervention and solution for justice, the petitions at the behest of diamond exports and dry fruits exporters where large sums are involved should be admitted and disposed of by this court at such quick speed. Neither justice nor equity nor good.
This is Navin Chand,
Yes, my lord. This is Navin Chand.
not Navat Chand. We are wondering what has happened.
Oh, yes, my lord. The printout is, my lord, NAVT,
We have found it as judgment. It's Navin Chand.
Navin Chandra.
You come to the first page itself.
Yes.
Second line. Masters G. Navin Chandra and Son.
Yes, yes. This printout we have taken from legal aid.
Legal. Legal side should be very. Legal side has failed us. What is the paragraph?
Paragraph 26. There is no equity of restitution
page?
against the law. Page 66. I mean, the
Before
running
parting.
page, running page of the company.
Before parting.
My lord, before parting.
There is no equity.
There is no equity in restitution against the law declared categorically and repeatedly by this court, and no principle of
Yes.
estoppel involved in this application. Now, my lord, the next decision that is, my lord, 1976 4 STC, page 20, Undavilli Nagaratnam. The relevant paragraph your lordship will get at page 70,
70.
paragraph 20.
Yes.
When a person with full knowledge of the law, ignorance of which is no excuse, enters upon a lawful transaction or executes a valid document, the right flowing from the law cannot be denied to those who are entitled to a benefit on the supposed theory of estoppel or a plea of contracting out by implication. Prabhu's case is not an authority for such a proposition. So conversely, my lord, since they are in ignorance of the law, by the ignoring the law, they have taken this benefit. That benefit, my lord, cannot accrue contrary to law. And that, my lord, on equity and law, there is another decision, D. Permananda, 2011 4 STC, page 266.
72.
Is transferred page 72. Relevant paragraphs are, my lord, paragraph 9 and 13. When there is a conflict between equity and law will prevail. Page 74, paragraph 9.
Yes.
When there is a conflict between
Yes,
law
sir.
and equity, it is law that will prevail. Equity can only supplement the law when there is a gap, but it cannot supplant law. And the last decision I'm relying is State of UP versus Bhupendranath Tripathi, 2010, volume 13, STC 203. It starts at page 78. Relevant paragraph is paragraph 19 at page 84.
Yes.
May I read it?
Yes.
Only one paragraph. A plain reading of the provision suggests that all such institutions offering a course or training in teacher education prior to the Act coming into force are entitled to continue such course or training until the application is disposed of, provided such an application has been made within 6 months from the appointed day. The consequence of not being able to gain recognition is the discontinuance of the course. Once an application seeking recognition has been filed by the institution within the prescribed period of 6 months, the institution is entitled to continue offering a course or training in teacher education until the disposal of the application by the regional committee. Once the recognition is granted by the regional committee to the institution offering a course or training in teacher education, the same shall relate back to the date of filing of the application. Section 14.5 reduced Section 14.1 enables the institution offering a course or training in teacher education on the appointed day to continue the course or training as the case may be during dependency of the application seeking recognition, and even in case of a refusal of recognition, the course may have to be discontinued only at the end of the academic session. The institution offering training or courses entitled to award degree or certificate as the case may be. So this will apply to, my lord, the institutions which were, my lord, in existence when the NCT so the course has to be started, my lord, after the application for recognition is submitted. Now, my lord, these are my submissions. So far as the, my lord, affidavit of the NCT is concerned, your lordship will find that, my lord, the query that was put, my lord, that has not been answered in this affidavit. That particular issue has not been answered.
When they have filed,
The affidavit has been filed on
8/8. The Purvia, 8/8. Naveen Mal,
11/8, my lord. We were served on 11/8.
filing date 8. But what have you stated?
This question, my lord, what will happen?
Mr. Purvia, what have you stated?
My lord, we have filed our affidavit, lordship. Here we have stated, lordship, the entire lordship facts of the case. Because, lordship, it is
Yes.
Yes, lordship, it is admitted that the date was extended for submitting application by the existing. But regarding existing or not existing, lordship, that we have no authority to state anything, because that would be better, lordship. The university as well as the college may state those things. But the fact is that, lordship, when the NCT Act came into force, lordship, the NCT wrote letter to the all universities informing about the enactment of the NCT Act and requesting all the universities, lordship, requested that to make the application for recognition. Even the university B.Ed college may also required to get the recognition from the NCT, lordship. But subsequently, what happened, lordship, within that very institute, lordship, that Hailakandi B.Ed college, lordship, when the university, Assam University, reply back to the NCT, lordship, they informed that there are 5 colleges under them. And then, lordship, we communicated with them that you have to request all the colleges to make their application for recognition. Subsequently, that date was extended and they have submitted the application, and ultimately, initially provisional recognition was granted, then lordship final recognition. So now, the lordship, whether that college, Perry College, was in existence or not, lordship, that would be better, because, lordship, Assam University, this is a central university, lordship, they have hold the examination. So without recognition, lordship, how they hold the examination? And even, lordship, the college also, lordship, taking all the lordship aspects for holding the examination. So that would be better to clarify by the Assam University as well as the college.
But in that case, how to overcome the statement? Without
No, Lordship.
example, he has
Yes, Lordship. That would be better to submit by the university concerned, Lord. Because how they hold the examination. Because, Lordship, our statement is that, Lordship, it is admitted that date was extended up to 18/8/1997. And then within that date, Lordship, they have, because when initially the university concerned, all the university required to reply back, Lord. When we communicated about the enactment and the functioning of the NCT, Lordship, to all the universities, the Assam University informed us that there are 5 colleges under them. Then, Lordship, we requested the university to
no, this is not regarding the recognition of it.
Yes.
It's the date when from which date did you recognize, did you give a degree which is obtained by a person who had appeared could it be a valid degree?
Lordship, that would be valid if the college would be in existence, Lordship. Because, Lordship, that 6 months, as per section 14, Lordship, that provides the Lordship, that 6 months was extended up to 18/8/1997. Then subsequently, Lordship, that was again extended, Lordship. But admittedly, that very college is applied within that extended period, Lord. There is a transitional period actually, Lord. Because earlier, Lordship, no email or nothing like that, Lordship, for communication.
How long?
Initially, it was 1 year, Lordship. Now it is 2 years.
At that time?
That time 1 year, Lord. Now, Lordship, we could not say anything, Lordship, because Honorable Division Bench, Lordship, held that the degree obtained in that year from that college is valid. So, Lordship, we could not say anything that invalid or valid. But fact is that Lordship,
Oh, that issue is there.
yes, Lord.
That is a big hurdle.
Yes, my lord, I satisfy your lordship, my lord, this was not the issue.
I think that here is the judge.
Yes.
Elaborate on
Yes.
three upon state, but not
Only Monday I will not be here.
Tomorrow, if possible,
Tomorrow,
case complete,
that is
case may be adjourned also. You may try your luck. Be patient.
no, in fact, my lord,
you transfer matter. If matters are done,
I understand problem. Keep adjourned, look, sometime, lot of cases are adjourned. So, lot will be free then.
Sir. depends on very please. Monday, you're not there.
Monday.
You- Tuesday,
No, what you
On earlier occasion, Lordship, Purvastha has mentioned the matter before senior court and diverted the matter to another court. Thereafter, tried his luck in another report. Because his 3 cases were also disposed of. That is why Lordship case was taken to another bench. Thereafter, Lordship, it was mentioned by my friend that was Lordship already heard. Thereafter, case has
My
been
lord,
taken in.
to sum up, my lord, there should be reflection that this is part.
Otherwise,
we would have been very glad if somebody else had decided. I've seen the order part by a senior
Earlier,
was when it was hard
in
in
this
leg.
particular case, Latif, my senior counsel has already argued for 2-3 hours. Thereafter, Latif, today also he takes more than
Where the test
full consider. It's not-
taken remember when the right
Latif.
was 3 to 4,009 that was 1050 of their base. Page number
And
three.
what my learned senior counsel has argued, I have no objection to that. My case is on different. My case is totally on.
Here, is there
Please, my lord. Hello, regarding item number 8 of today's daily list. In respect of the MAC appeal number 83 of 2022, my lord, we filed an IA for which my lord may kindly fix the short date.
I8 item number 8?
Item number 8, my lord. In the MAC appeal.
What is the
my lord?
I for?
IA for, my lord, actually the other side, along with the repeal, had filed an IA for which this honorable court was pleased to say the judgment of the learned
You're
tribunal.
for whom?
I am from the
You're for the claimant.
claimant, my lord.
You have filed the IA
We have again filed an IA, my lord, for giving 50% of the compensation.
where is your IA? IA number? 2086,
My lord, IA 690 of 20.
not listed.
Not there, my lord. There. 690.
Thank you. I think the IA is good.
690 was the IA for the stay, my 2086, my lord.
It's there. It's what you want for the release of the
No,
Release
the
of-
stay was granted till disposal of the appeal. They have not filed a petition for vacating of the stay order.
what is this IA?
This IA, earlier the IA from the other side, my lord, was to pay the judgment of the court of the learned tribunal.
MSP.
Yes.
Your IA?
When we have filed an IA for the release of, if possible, my lord, 50% of the award, compensation award that was given.
That case.
That case,
That case. How much is them?
It was
7,60,000, 7,280. Latif.
What are your grounds of that?
Latif, there is no dependency factor, Latif, because they are the measures on other type. All are measures on. They have own income, they have service, but
They will not get anything.
they will get something, Latif, another head of pain and suffering, Latif, loss of estate. They will get.
And must say of the entire award should be fair.
Latif.
In an MSc award, you are
Okay, the workout record has come, Latif, and service is also complete. That may be
matter. Why should we hear it?
for vacation, but
No, why? There are matters of 2010 and 11. But stay without condition for deposit. Is don't stay without ordering some deposit.
it up to 2 lakhs.
2 lakhs.
How much have you paid for?
We paid for 50,000 square feet.
50%.
50%. That is 3 lakhs
50%.
30,000. 50%. That is 3 lakhs 30,000.
You pay, you, 10 lakhs, 2 lakhs. Third, what is your name?
MP Chaudhary. On behalf of BREC.
M.K. Chaudhary.
MP Chaudhary.
Not the MP Chaudhary on instruction of BREC on applicant. The applicant to the patent and arrayed as respondent numbers
No, 1 to 4.
1 to 4 applicants are and by means of this application has paid for an order for order for deposit of 50% of the awarded amount by judgment and award dated 6/12/2020 passed by the learned M.P. Gonzalez, 7 company by state judge, the learned tribunal had awarded a sum 7.6130 this court by admitting the on 15/3/2000 had also passed an order the accompanying IA 690 of change into judgment and word. Chaudhary the response was applicant that and a direction for deposit 50% of the awarded in consideration that case solved that the claim was for the death of the father of applicant had occurred on 19/5 at Atsal. We take a photo that concept opted for applicant out of sub that the word not resolved as there was no dependent factor that either is into the object the act the benefit of this direct that while the impute award would remain is the same subject to payment of a lump sum of 2 lakhs by opposite party within a period of 60 days in the registry of this court. I can support the applicant payments get put withdraw the state after submission of a bond and on property item by the DPO. Yes, ma'am.
He jumped the queue, so Lordship, what happened here, Lordship, they have mentioned it, but the thing is, respondent number 3, Lordship, we have to take fresh steps on them. And I pray that we take by Dusty Service, Lordship. They are the owner of the
Why
vehicle.
is it discussed?
Lordship, they mentioned it that someone, respondent 4 mentioned it.
Who is-
They just, no, they are not there, and we have been waiting from early.
Who is 4?
4 is the driver.
Driver.
Yes,
Correspondent number 1 and 2.
Why is the driver? Who is the AM?
it is there, Lordship, and at the back of the file, the mentioned memo is there.
What was it? The service is not complete.
On 3 only, Lordship. So I am praying that we may be allowed to take Dusty Service on them, Lordship, because we have taken on the 3 address, Lordship. That must be mentioned.
Part of the current council. As well as your as per one. As well as per one and council correspondent number 1 and so this case attention of the learned council for the who had also filed mentioned memo, comma, the state respondent for is not represented. MS, sir, learned council by reference office has
Dating 9.
submitted that respondent has not been able to serve accordingly. Submit that party may be granted to serve the state responsibility by Dusty with further liberty that such steps may be allowed to be taken on all the 3 available addresses.
Yes, sir.
Revert the responsible by Dusty on all the 3 available addresses is allowed. Fix the next date as as 10th of October. The Dusty Service, however, but the registry of court and in notice accompanying the connect it to be inspected. The appellant is also certified and if it prior to the next week in support of such justice.
So, Lordship, the date from 10, Lordship, can it be shifted to after vacation? Because they will also get 1 month time.
Who?
Whom we are serving. The
10th is on what service.
service.
We'll see whether they're appearing or not. Or does don't need 1 month can service to
Highly obliged.
I did the vote after 10 days.
Which one?
I think no 14 miler.
4. But
Miler.
any other was that?